Hola. Good morning. How you doing? How you doing? How you doing? We should probably get started. Let's get it started. Let's get it started. 10 to 15 minutes to go. You have no faith in me, Mr. K. No faith at all. It's like an Asian legal mindset. Let's get it started. Hey, weepy grinder. Really should send out notices. Oh, for crying out loud. They say 8:30. 8:30. That's what they said. They said 8:30. That's what they said. They said 8:30. Guten Tag. Gosh. I'm gonna send out notices while I'm waiting for them. There's no trial yet. There's nothing. There's just you and me sitting around like a bunch of idiots. That's basically what we have. It's just you and me sitting around like a bunch of idiots. I don't know. It's like this judge trying to make us look stupid. What the hell our stinking problem is? Look at this. It's a long crime showing. Like a bunch of idiots. I'm doing a 48-hour stream. Actually, I'll tell you right now, I'm probably not going to be. I don't expect to be streaming this afternoon. I don't think I'm going to stream this afternoon. I haven't decided yet, but I don't think I'm going to stream this afternoon. I think I'm going to sleep like this afternoon and evening. I think I'm going to shut down after the morning. This is my plan right now, internally. My brain is saying, stream this morning, set up my stream for tonight, close out and redirect everyone over to like one of my friends, someone who I like. I have to decide which of the people that I like to send y'all to. And then after that, I'm going to basically set up my stream, go to sleep, and wake up and do my 24-hour stream. Good morning, chat from Michigan. Oh, look at this.
I'm sorry, I didn't mean to FaceTime you. Last night you went through those pictures and you printed out like a
there was some stuff we left last.
Yeah, you guys suck. Okay, nothing's happening there. I'm going to set up my notifications, let people know that I am live, because I never did that, and that's part of the reason why no one's here. Because I think people expect me to send out notifications. I've built that into the audience where they're like, oh yeah, he'll notify us on Twitter. Control. Send it out on Twitter. Send it out to my YouTube community. You just start saluting people. I do secretly love legal. It's true. It's true. It's the hair. How can anyone say no to the hair? Oh, I was trying to think what I wanted to do. What I wanted to do is I wanted to redirect. I'm definitely adding a redirect. What's this? Does he break it up also? Why does he have two? He has two. Why does he have two? That doesn't make sense. That doesn't make sense. That doesn't make sense. Why would he do it like that? I don't understand that. One of the things I'm definitely planning on covering during my 24 hours is the Fanny hoax. Another thing I have is in my Discord. There's a whole thing that's set up for me there. Courtesy of my local folk, my diggers. Let's see what they Mm-hmm. I should be talking to you. Morning. You have to write it down to show Jim Brewer 3-minute stream of Trump derangement syndrome. This is what's happening right here. There's nothing happening there. This is why I don't like trusting a court when they say this during 8:30. Because I know how courts work. They say 8:30. They say 8:30. And they don't mean 8:30. This is what being a litigator. I'm gonna tell you. So now, okay. Let me explain something to you. Okay. This is one of my frustrating things about court in general, is that there's some judges who will say 8:30, and they literally mean the bell is going to ring at 8:30. And if you're not there, you're going to get chewed out hard, like humiliated. And then there are others who say 8:30, and that means 9:15. And there's really no way to know. And here's the really frustrating thing. Even the ones who say 8:30 and mean 9:15, every once in a while they'll start at 8:34. And you'll be like, that's just not the way things are done in your room. You're saying there's bad weather this morning, snow and accidents? Oh, in the Detroit area? I don't know what I'm doing up. I don't know. I feel tired as anything. I feel really tired. This is what I'm going to do, though. While I'm here, I want to see something. Your keys are in my coat? They're definitely in my coat.
Where's that?
Keys are definitely in my coat. No, the family's not asleep. They're all up and running around. I'm just, I'm waking up. I'm not going to kid you. I'm still waking. I'm waking up. I don't know what you want to tell you. What do you mean jury's in at 9:30? Is that what they said? Is that what they announced? Is that really what they said because of the snow? Please tell me you're kidding. I got coffee. I got coffee. Seriously, did they really say jury's coming in at 9:30 because of the snow? Oh no! See, this is the mistake I made the other day because apparently they are on Eastern time zone. Who's SS? Who's SS? No, I know that she specifically announced 8:30 yesterday when she wrapped up. Told the jury 8:30. Oh, defense counsel? This is ticking me off. I want to see something. It seems as if the attorneys here are well aware that 8:30 is not the right time. I mean, they're just first setting up. The 24-hour team stream starts at midnight tonight. Bum, bum, bum. We will ask the questions. I have a thought here. I have a thought. I have a kill time thought, like an interesting way to kill time. This is something that just sort of put me on the spot here. We gotta think on the fly.
The names from the gifted memberships. All right. Or I don't, but other people like hearing the names. All right. Kathy Trout was gifted a membership. Kathy Trout has a wrench, but no membership in my channel. Just want to say that. Jody. Okay. Toyla Carissa. Is that Toyla Carissa? Is that, am I saying it right? Because I don't know. I always see you in the chat, and I never say your name because I don't know if I'm saying it right. Bama Rose and Kathy Hutton We're all gifted memberships thanks to future Mrs. Martin 2.0. I appreciate it very much. If you guys are new members, remember to click the membership tab.
I just asked him to send
I
me
have
a
my
link.
notes from today
Crossover with him.
or from yesterday. I have all the
wait.
jury information, a bunch of stuff on this case, prior
I'm
motions
just
that
going
have
to
been
cross over
filed,
with him while
court
we wait.
opinions and stuff, and then a
talk
bunch
with him
of
about
other
the
stuff
trial.
from a bunch of other cases. We also have, other streamers that are in my channel, such as the Broken Baker and Nick and Excited and all kinds of people are on there. McKinley even too. McKinley is in my chat or in my Discord.
That's what I plan on doing.
Ray, Jamie's here. I know that's the only reason Broken Baker's here is because Jamie's on panel. All right, let's keep going. We don't have a live court feed yet, by the way, everyone. I have the window open. I am waiting. You can see it right here. We are just waiting for the court to open the window, and as soon as we do that, we will go with it. In the meantime, we'll keep going with this video.
Stop with the video. The video is
Jamie,
boring,
if you want to
David.
yell at the screen, just let me know.
It's bad. It's bad. It's bad. You can...
Hey, check your messages, David.
Yeah, the messages.
Oh, hey, Joe. All right, let me send you a link.
Thank you.
What we'd like to do, talk to.
Thanks to
When the
Baker,
trial
too.
starts up, I'll come.
Messaging me saying, hey,
I'll
go
The
see your
full entire meeting. That's gonna be all up to you guys.
I'm messaging Andy right now.
All right. So now the way to do this in a way that's not going to be annoying.
Oh my God, I gotta find you on X, man. There you are.
Handle.
All right.
Andy,
Just so
1050 something.
We would.
All right, you got
a lawyer. What's from here on out.
So the way to do this is does not echo on the delay.
It's just.
Is let's mute myself here.
I only see this stuff on TV.
I'm done.
Oh, no, I talked to
Recording
my
in
counselor
progress.
about that. He talked to me and we went down there.
I hate that video. The video is so annoying.
And he didn't seem worried about it. And
All right.
he said he was more welcome to stay at school or he could go home. And
I'm gonna go
really
there
wanted to-
and bitch with him about this defense counsel. That's basically what I plan on doing. Need to mute myself.
Joe, I sent you a link.
I'm coming.
Good day, sir. Sorry. Good day, sir. Yeah, we're done. We're done.
You,
Sorry.
how are you?
Oh,
Turn it
okay.
down for a minute. Turn
So-
it down
yeah.
for a minute.
We're
All
done.
right.
Oh, you
Because
are,
that
yes.
video- that video
Because
is
of the
very
way I have
annoying.
the
I watched
screen
it
set
last.
up. Hang on, let me do this. Oh, okay. There we go.
I
How's
hear
that? That's
myself
better.
echo now.
Oh, you are, yes. It was because I was sharing my whole
Let me
screen
do
the way
this.
I was playing.
There
There
we
we go. How's that? That's better. It was because I
we're
was
good, we're
sharing
good.
my whole screen the way I was No?
I
playing it.
gotta figure out how.
Okay.
Oh, that is good.
Yeah,
No,
sure.
it's not good.
No?
No, it's. But I think it might be on my end.
Okay.
Give me a second.
Sure,
Give me a
sure.
second to figure this out.
Well, while Joe is taking his time to figure out his system, Jamie, what are your thoughts? Well, while Joe is taking his time to figure out his system, we do have a court feed Jamie, up, what by are the your way, but thoughts? nothing is live yet.
I feel like we talked about this a lot last night, but I have a real,
We
I
do
just
have
have
a
a
know the
really big
problem,
problem
by
with the
the way, but
state
nothing
and
is-
their accusations of like
All right, I figured
how
it.
the parents should have acted.
This is confusing
That's
to
like
my
my biggest
audience.
problem.
Step 1, I want a lawyer. Alternate step 1, I have nothing to say without a lawyer. Step 2, shut the fuck up. That's about right. Although they didn't say anything terribly incriminating at all.
No.
In fact, what they said corroborates their position that, listen, we got this piece of paper this morning. We were concerned he was still in school. When we heard about the shooting, we went home and looked for the gun and we called you right away. He's a good kid. He's never done anything like this before. And everything is consistent with their position that they literally have, none of this was foreseeable to them.
100%.
Yeah, I can hear you just fine. Yeah, what are your thoughts? I was yelling at her yesterday, although I will say yesterday was much better than Thursday and Friday. It was a disaster. Did you watch it all last week?
week. I did.
I
did.
Jimmy's doing her thing.
Oh no, I didn't watch much of it. But
Okay, she was a disaster last week. She kept apologizing. She kept stepping on herself. She looked frantic trying to go through exhibits. On Friday, when she was going through exhibits and she couldn't get it to work right on her computer, she's like, I want to kill myself. Oh my God, I want to kill myself. Yeah. Yeah.
No, she seemed very green. That's basically what I saw yesterday, was that she seemed very green. She has no strategy. She has no idea what there's no game plan. There's no nothing. When that counselor came out yesterday, I mean, he was like a T-ball softball for her and the case right there. Because she basically, and this is, you're a litigator, right, David? I mean,
Yeah.
Okay. I mean, I'm watching her. I'm watching him. And before she started, I was like, this is what she needs to do. This is probably, and I laid out like a several step plan. I was like, how you need to sort of walk through where, the different things to set up the steps that he took and the level. I like the fact that she started off well in establishing foundation of trying to build up whatever level of expertise that Shawn Hopkins has, as far as that detecting a threat, a kid who's a threat to himself or to others, which it was unfortunate that he doesn't have more experience, but he even could have hit on the school. Are you the only one in that whole school who handles suicidal kids? Because it's apparently, look, the morning of November 30th, they thought the kid was suicidal. That's what they thought. If the court starts up, let me know, by the way, because I'm certainly not looking to take away from the trial. But I figured it's a good thing for people who are lawyers and watching this case to sort of like, or litigators, to share our thoughts about the work product of the various parties here. And that's why I was like, I think this is good. I also plan on redirecting over to you after I'm done with my stream. So
I appreciate it. One of the things that I wanted to point out, that I did point out yesterday, is specifically when the counselor said, I'm not a disciplinarian, I don't do discipline, and kids don't get sent home unless it's a discipline issue. I would have crossed him completely differently about that. She kept trying to ask about hypotheticals, or what if the kid is sick, or what if this? He's like, well, that's a hypothetical. I'm not good. In your entire tenure, has a child ever been sent home? Are you aware of a child ever being sent home for
what was a hypothetical? What if the kid's a threat to other kids? Do you send him home? If he's a threat to someone else, if you're worried he's going to stab another kid, would you send him home?
But he kept saying, well, that's a hypothetical. I can't answer. That's a hypothetical. All right. So I'd change up my tactic. I would be, all right, in your 20 years as working in a school, are you aware of any time in which a child was sent home for a non-disciplinary thing? If he says no, he's a liar. If he says yes, then we say, okay, what was that thing that you can specifically recall? Okay, so great. There is an opportunity to send people home for non-disciplinary reasons. Now we just established that you were lying earlier, right? That's the strategy that I wasn't seeing from her.
I wanted her to build up all the different signs that were there that he was a threat. And then, in other words, the state is making this case. What is the whole essence of the state's case? The essence of the state's case is that her gross negligence led to a situation that it was foreseeable that he was going to go do this. That's the entire state's case against Jennifer Crumbley, that she created this foreseeable scenario where he was going to go and harm kids, and that she did nothing to stop this, even though it was so foreseeable. Well, if it's so foreseeable, you're the person here who's been working with kids for decades. You're the one who has training and expertise in identifying these things. And the picture that you saw, this is how I anticipated it would happen with a skilled litigator. That the picture that you saw led you to conclude that if anything, he was a threat to himself, not a threat to others. And I would start yelling at him that it's his fault that these kids are dead, until he's crying. I would have him practically crying on the stand and play into his guilt, because I'm sure he's feeling guilt that he failed to identify it. And I would play into that guilt, and I would have pressured him and saying, you see, you should have seen these pictures. You knew he was researching guns and he was researching bullets a day earlier. He's drawing a very detailed picture of a Sig Sauer there. That's not like a picture like a gun, it's like that's like a stick figure drawing. That was a kid who looks like he's seen that gun before because he's got like the shading on it and everything there. You saw this and you failed to identify it, and that's why 4 kids are dead. I would have played into this I'm sure he said he got counseling afterwards. I would have played into that and basically dug up all of the guilt that he was feeling until I made him defensive and made him basically say, no, it was not foreseeable. And that way, by him trying to protect himself, you say, aha, you know what? At the end, you close out and say, you know what? I agree with you. It wasn't foreseeable. It wasn't foreseeable for you, who is an expert, and it certainly was not foreseeable for my client, who's not an expert. Now, I know at some point he probably would have said, the whole picture would have been different if I knew he had access to a gun. But even when he tries to deflect, and meaning to try and distinguish himself from Jennifer, and if and when he likely would have gone down that road, you say, well, did you ask him if he had a gun? You saw he was looking up bullets. Did you go through his backpack? Did you go through his backpack? Did you go through his locker? Did you even ask him if he had a gun? You saw that he was looking at videos of school shootings that morning. Did you even tell my client? You never even told my client to take him home. You said eventually he should get counseling. But you never said that. There's so many ways you could have made him feel like total crap, that these kids who he knew those kids, presumably, or some of them, and I'm sure he knows their faces and their names. I'm sure all over the school, they have all these, remember Zachary or remember Jennifer, whoever these victims are. I'm embarrassed I don't know their names, but that I'm sure he knows these kids, and I would go through their names one by one and say to them, Zachary is dead because of you. Jennifer is dead because, until he's crying there on the stand and trying to be defensive. And then you coddle up to him afterwards and you say, it's really, there's no way it was predictable. No one could have seen this. You couldn't see it. We couldn't see it. No. What do you think of that strategy? Is court starting?
No, I think that would have been great. I think that would have been a great approach. I just don't think this is the attorney to do it.
Yeah, that's the problem. Is court starting, or they just milling around there? I hear the background there.
Hang on. Right. So they're starting the case up.
All right. I'm going to back out of here. But I'm going to drop a rate on
appreciate your insight. If you want to come back anytime, let me know.
Number 22279-990 F8.
Thank you, Mark East, on behalf of people.
Good morning,
Donald, on behalf of the people.
Good morning, Your Honor. I'm Sharon Smith on behalf of Jennifer Crumbley.
All right, so last night when I heard about the 55 pictures, Ms. Williams went back and called all of the jurors, all 17 of them, and asked them to not come in until 9:30, which I guess is working out well because they're also calling about the snow. So they're not going to be here till 9:30, which is good. I don't like the jury waiting while we're doing whatever we're doing. So I also believe that Ms. Smith had the opportunity to look at various pictures that were presented as evidence. I looked at all the pictures last night and I compared them to your objections to Smith, but then I thought to myself, I don't have a copy of the pictures that they agree to yet, so I can't tell if things are redundant or whatever it is.
That's why I was having a hard time, because I could see what they take out, but I couldn't see what else was there. But we have good news.
Yeah.
I eliminated it, and we have far less objections.
Okay.
And then the prosecution is also eliminating 2 more.
Okay.
So I'm just trying to make sure I have the 2 they're eliminating. And then number 215, right?
215.
Okay, so 215 is out, 247 is out.
215 is out, 247.
Okay, so then I no longer have an objection to 216. So I have, I essentially have 2 very narrow sets of objections.
Okay. Go ahead.
Okay,
Yeah,
so,
I have your list, and I looked at all the pictures, and I have your exhibit list as well, so.
okay, so first, exhibits 22 and 23. I'm sorry, 220 and 221.
Okay.
I am asking that one or the other be admitted. It makes it look like,
I'll meet your desk here. Hold on
sure.
a second. I think I know which ones you're referring to, but let me get them. 220 and 221. Who, is this in the same room?
Yes, Judge.
Okay,
It's the same picture, one's just focused in, one's focused out. I would just ask that one of those be struck so it doesn't appear that there are two of what is in those photos.
okay, who's, is this the same room? Whose room is this?
That's that's Mrs. Crumbley's son's room.
Okay.
This is such a stupid tactic that they keep saying Mrs. Crumbley's son.
They
So
pretend a
dumb.
similar thing,
It's
right?
the same thing. The testimony would be clear that it's
I hate
the
this
same
attorney.
items in the same room. It's just to give perspective for the witness and the jury.
Okay, so what's the difference? I guess the question would be why do you need them both?
Just to show the perspective of the location of everything.
Well, it appears to be next to the bed, right? So is it this one? Sufficient? Oh, it doesn't, maybe you can't tell what it is.
Correct.
Yeah, that's the thing. This shows where, 221 shows where it is in the room, and 220 shows what it actually is, right? In other words, 221 shows that it's next to the shooter's bed, and 220 shows that it's whiskey. That's the reason.
I understand that. I believe that the photo from farther away, you can tell what it is. And that's simply my objection, but I understand if the court. is
Yeah, I mean, at first I would,
Over objection.
at first I agreed with you, but I don't think that, I don't think you can tell this is whiskey from a whiskey bottle from this photo. I mean, I guess you could argue it. So anyway, I'm gonna allow them both,
Thank you, Judge. That's 220 and 221.
correct?
Okay, and then the final argument is about exhibits 242 through 244. I am asking that the whiskey bottle in those three photographs be redacted because the whiskey bottle is irrelevant. It's, the video games were not in the Mrs. Crumbley's son's bedroom. That's from in the house in general, so the court already ruled that alcohol and whiskey bottles would not be in. So I would just ask that those whiskey bottles be redacted from those three photos.
I guess, the ruling, I have the transcript of the ruling, it was more that, someone having, alcohol in their house is not, indicative in and of itself of gross negligence. So that was the idea.
Well, I feel like, the defense argues that it looks like there's possibly three different alcohol bottles. And so it's unnecessary to have three alcohol bottles in those photos.
Yeah, well, I guess I'm gonna ask, what's the purpose of it aside from throwing dirt at the defendant?
It's the same whiskey bottles in the defendant's room, Judge. That it's clearly not three different bottles. You can tell from the pictures that the video games were,
This isn't in the defendant's room, is it? This is in the kitchen?
no, 220 and 221.
Or the defendant's room?
Correct. It's the same.
Wait,
brand.
221 is the shooter's room or the defendant's?
Shooter's room.
The shooter's
room, yes.
Okay.
I'm sorry, I may have misspoke.
Okay, so then, Your Honor, if that's the same whiskey bottle, it's clear they put the whiskey bottle.
No, it's not. That's not what I said. It's not
Okay.
the same whiskey bottle, it's the same whiskey brand. The 220, 221 clearly is empty.
Okay.
242, 243, 244. That's where this bottle with alcohol in it was found. It wasn't placed there. It's just one bottle. That's where it was found.
Yeah, I'm gonna ask you to redact the whiskey bottle. I don't, barring some other evidence, the only reason to admit evidence of there being alcohol in the house is to attempt to ask the jury to believe that if someone has alcohol in their house, they might be a bad parent, or to connect it to the bottle in his room like they gave it to him or something. Right?
Well, he was 15 years old at the time of the shooting. It's the same brand that was routinely purchased by the defendant and her husband over a period of weeks and months. And it's the same brand that was recovered in the art studio where they were found on December the 4th. So we do believe it is relevant, especially in light of the stated argument that defense is going to put forward.
Because I'm on national television, I don't want to tell you about the things I did when I was 15 years old. But the shooter could have taken this, right?
Taken
Or
the
bought
photograph?
it. The whiskey. Like, the jury shouldn't be able to imply that, unless there's evidence to the contrary, that the defendant and her husband were giving the shooter this.
If we exclude
The
defense counsel
has stated
doing a
specifically that the
garbage
defendant
job,
was
then
a
yes,
hyper-vigilant
you missed
mother.
you missed
And if that's
nothing.
going to be the argument, that people should be entitled to explore what that means and what it doesn't mean. So these photographs were taken on November the 30th, the day of the shooting. The bottle with alcohol in it wasn't placed in the photograph. Detective Stoic will testify that that's just where it was found. He will testify that the empty whiskey bottle that is the identical brand, the one found.
That's not me. That's law and crime doing law and crime type stuff. So I'm sitting here hazing Linda in my chat. That's basically how I'm amusing myself while they're arguing over exhibits. There's arguments over exhibits, which we don't even know what those exhibits are, don't know what they are sharing. Really makes it difficult for us to appreciate the significance of the exhibits that they're haggling over. I should get a long crime overlay. I missed this earlier. I don't know enough about the whole Karen Reed story. I had someone else telling me I'm not sure if it was you. I think it was someone else telling me I need to cover the Karen Reed trial. But I don't know enough about it. I know about Zachary Anderson. You know, in the movie Snatch, which is one of my favorite movies, I think Guy Ritchie is a very underrated director. I think I really enjoy his whole style of filming. When they hold up the bookie. So at one point there's a holdup there. So they end up holding up this gambling place. And the woman behind the counter is, they're like, give us your money.
They were concerned about that. So,
I believe we are still ahead of our initial schedule.
okay, so you think you're going to rest sometime this week?
Yes, sir.
Okay.
That's our hope.
All right.
Your Honor, I would ask if the prosecution is not calling some of their listed witnesses, they let me know, because there are witnesses on their list I intend to call if they don't, and they're aware of who those witnesses are.
Okay. You can do that, right?
It just depends on how the trial progresses, obviously.
Okay. Well, she might ask you to produce them. That's why.
They know who I'm asking them to produce.
Okay.
I've already given them a list.
All right. So we'll have a full day today. We have this, is it Stoic today? Stoic.
Well, like I said, we're working on schedules, but
Okay.
Stoic, Sergeant Pesky.
Okay.
Nate!
I'm trying to think what else on my list.
I'll send you a link. You don't have to come by, but if it works for you.
Set of instructions. You both set sets of jury instructions. The jury instructions went back and forth, and then I sent you what I believe is a final set of jury instructions. I realize that they might need to be changed a little bit, right? So if there's anything different or any objections to the current jury instructions, let me know as soon as possible.
I don't see any at this point, but Judge will certainly keep an eye out.
Okay.
I don't either, but I obviously will have to revisit that after the proofs.
Okay.
Also, proposed exhibit 424 was the interview transcript. I referenced that yesterday.
Yeah.
We provided a copy to defense counsel yesterday. What we have marked now is redacted in accordance with the personal information that was redacted on the audio that we
Oh,
showed.
I see. Okay.
Your Honor, I got this last night. I
Okay.
still need a few minutes to review it.
Okay, that's fine.
Thank you.
That's fine. it would just be, if the
All
transcript's
bets
accurate,
are
I think,
off.
admitting it. The idea
I
would be
appreciate
if there's something inaudible and you do not agree what was said.
Right.
I'd either have to listen to it or
It is better.
take it or whatever it was.
Well, it's not a transcript that was done by a court reporter.
Right.
It's a transcript that was put together by the prosecutor's office. So I just want to double check
Sure.
to make sure that it's accurate,
Sure.
and also that there's not a side commentary in there that the jury should be making evaluations on. So for example, if this says, "Who is crying?" I would object.
Yo, Joe,
How are you?
what's going on, man?
I'm watching this defense counsel just bury Jennifer Crumbley. She's like putting a rope. She comes with the rope and she just like throws it over her client's neck and just tugging.
Thank you.
Any other housekeeping issues right now?
She's so ill-equipped for this.
Ms. Smith, anything?
It's
No,
sad.
Your Honor, but I just have like 2 pages left, and it looks like the transcript is actually fine. I just needed to review.
What are they
it.
arguing about?
Let me just give me
Exhibits.
1 second, and I think-
Which we don't even know what these exhibits are, so it leaves us very confused.
Yo, have you? I'm doing all right. I'm just looking into the Trump, E.G. and Carroll stuff because I was like, I'm gonna do a video on it.
Mm-hmm.
I went down the rabbit hole. You're talking about a judge that was just after Trump. Like you know, I don't really like Trump, but my God, you got to look through the facts of that case. It is insane how the judge like went above and beyond to get Trump.
Can you give us a synopsis?
All right, I'll make it very clear. So, 2019, she sues Trump, saying because Trump said he didn't blank her with the R word. Then New York passes the Adult Survivors Act.
Mm-hmm. And that was
That essentially says anybody who feels they were sexually assaulted in the past 100 years can sue right now for a year.
and forget
that
about
was-
the statute of limitations.
Yeah, don't worry about it. So that's why you saw even the mayor. The mayor got sued. Everybody, like, you know, P. Diddy got sued. All these people got sued. So she sued Trump under that. So then the judge, so they went to trial. In that trial, the jury rejected the rape charge. He's like, that didn't happen. But we'll give you the battery. Essentially, if you slap
Essay.
yeah, if you slap somebody's behind, that's an essay.
Mm-hmm.
But they said no, he did not blank her. He did not do that. So that the jury resolved that. So then she said, so then Trump goes on Truth Social and says, I didn't blank her, I didn't, the R word, I didn't do that. She then sues him again, saying no. He now defamed me again by saying he didn't R me.
Mm-hmm.
So Trump's lawyers go into court and it's like, yes, he did not R her. You know why? Because we have a jury
That said,
rejected that said he did not R her. So you
Mhm.
would think it's over, right? You would think, all right, she doesn't have a case. The jury said he wasn't.
Truth.
didn't R her.
truth is a defense.
You know what the judge said? The judge said, no. Trump's lawyers, you're wrong. People under the colloquial definition of what R is believe that SA is R. So we're going to go to trial on that. Even though the jury said you didn't R her, they said you SA'd her. But people generally think of that to be R. And that's what he found in summary judgment that meant that Trump defamed her by saying he didn't R her, which was true. And-
Which, by the way, how you give summary judgment, because that should be that issue alone should be a question of fact as to whether or not people colloquially refer to that as essay as R. Because I don't think that's true.
No,
I don't think that's true.
either. But what he said, what the judge said, was the fact that the previous court found him liable for SA. That was summary judgment for the R. So he
Right.
essentially had the R. He essentially did the R, and he had actual amounts of it. So it's only damages. That's where that $83 million comes from. It literally comes from him being found not liable for R,
Mhm.
saying he didn't R her, and then the court saying, well, generally people think R is this, and we're going to make you pay $83 million. I'm like, this guy has a great, how can this stand? This makes no sense. It literally makes no sense.
But
I'm like-
he's Trump, so it might stand.
But even you have a jury saying you didn't R her, And the judge is saying, well, even though they said that, they really believe that you are. I was like, what? Like, that makes no but you have to read through the whole case to figure that out.
Yeah.
Because I was like, this doesn't make any sense. If they said she didn't do it, he didn't do it. And the evidence was insane. So she literally supposedly kept the black dress like Clinton. I don't know what's all these black dresses. From 1996 to recently, she had a black dress that supposedly had some DNA on it. They tried to get a DNA off of Trump. There was no sperm on the black dress. Nothing identified as sperm. So they're like, okay, if this is the only evidence she got, there's nothing that says, that on the thing. So we were good, right? No. Obviously, it's she still told somebody. So forget about all that evidence and stuff. Like, it's like reading through it. I was like, is this really happening? Am I reading this right?
It gets worse than that. I don't know if did you hear about the relationship between Lewis Kaplan and Roberta Kaplan?
No.
Oh, you're gonna need this for your video. Roberta Kaplan, who was her counsel, did not simply work with the judge at Paul Weiss, but according to various news articles, he was her mentor. They had a mentor-protege relationship between the two Kaplans, the judge Lewis Kaplan and her counsel Roberta Kaplan.
Wow.
And he doesn't recuse himself. Instead, he just takes this case and gives her summary judgment. It's it's astonishing. It is astonishing. And that's from like members of Paul Weiss said that they had a very close relationship and he was her mentor. Unbelievable.
That itself isn't.
It's crazy.
But now you know what? It puts into context how the judge can rule.
You need
all
to
of this stuff.
You
It
definitely
makes sense.
Yeah, you're definitely going to want to. Well, it's also the TDS, but you definitely going to want to have look up what I said. I'm sure.
Of course, I'm looking it up. Yeah, I'm doing it.
I'm sure. I'm sure you'll find something.
Listen, people, to people in the chat, you guys got to know I am not a Trump supporter by any means, but my God, this was like really just reading through this was like, am I really seeing this go down? Like a jury literally says you didn't do this, and you're being sued for defamation for doing what the jury said you didn't do. It's like, how is this possible? But when you're Trump, it's possible. And $83 million, $83 million,
of course,
for saying essentially saying the jury found me not guilty of blank. You pay $83 million because you're defaming the person. No, that's what? It's crazy. It's crazy.
Yeah, the lefties in your audience are not going to be happy with you for this, but I know you don't care.
Oh, no. I read the documents. I give the facts. Whatever you feel about it is what it is. I don't care. That's all I got. Go ahead.
We're the two New York attorneys from the online legal community who have like a YouTube following. So like we're the it says how does it make you feel about like the law you practiced in New York? Does it make you feel like embarrassed that like between Engerangan and Lewis Kaplan? I mean, Lewis Kaplan is federal court, but still, it's federal court, Southern District, New York.
Yeah, it's Southern District. Well, to be fair, Igran, I think his has a little more legal basis because I read through that complaint and all that. So I'm like, all right, I see. He's going down, even though I do agree with anyone else not named Trump probably wouldn't have this problem. Everybody got paid. Everybody's happy. The bank's matter of fact said we would do it again, right? So there's no harm, no foul, and everybody's doing it. So I do think this is selective prosecution. But
it's not just selective prosecution. One of the things I think you may have missed about that is the judge said the reason why his defense, what's his main defense, is that his cover letter says don't rely on the representations.
Yeah. Do your own background. Mm-hmm.
So he looks at it as it's a CYA where it's just basically like if there can't be fraud, if I tell you don't rely on me, because an element of fraud, as you're aware, is detrimental reliance. And that cover letter is saying don't rely on me. So the judge said you cannot use that in a situation where you alone have access to information So they must be reliant on you because you have personal information that there's no way for them to get. And because you had personal information that there's no way for them to get, that's why there's fraud here. The problem with that logic is, what's the personal information? A valuation on a property that Zillow has. That's not something he personally has. Some of the stuff they're saying he lied about is they're saying he lied about how many floors were in a building. That he said that there was 20 floors and there was only 14 floors. This is stuff that's public record. That's not information that he alone had. Anyone who does due diligence knows how many floors. He says that the reason he wrote 20 floors is because he was saying what it could be built up to because they had air rights and things of that nature. But not that it had 20 floors necessarily. But if they were taking it as him making that representation, these are publicly accessible documents. It's not a top secret as to how many units are built up on some property in Scotland. You go there, you check the records, and you find out how many units are there.
Yeah, you look to see what's there.
So the whole underpinning of the judge's logic that it's knowledge that he alone had access to is crap. It's not remotely close to true. And that's the only reason why his protection of that cover letter was deemed invalid. So when you're saying, that's why I'm like, no, this case doesn't have any legs to it. There's no one was defrauded. The bank says they would do it again. That he has a cover letter, and the cover letter should protect him because at the end of the day, there was no. This is not inside information that he alone had access to. Everyone had access to this.
I agree with all of those points. But my only issue with that is that the law is in this particular realm is so freaking narrow that even with that disclaimer, because that's what you're talking about, the disclaimer,
right?
It still says if you misrepresent it, even if because the banks knew what was, and the bank still said, okay, we're still going to give you this loan because we agree. The banks did their own due diligence. The banks don't, just for you people don't know, if you say your house is worth, the banks aren't going to trust your number. They'll say, okay, this is where we'll start, but we'll look to make sure that so I agree 100%. The banks weren't fooled, but their whole thing is that if you make a representation, you can't put a disclaimer on a form. It's just whatever that is, you're supposed to be truthful. So I agree with you. I think, and just like what's his name, Kevin O'Leary, Mr. Wonderful from Shark Tank, he said the only problem with this is that you're right. By the technical, if you want to be as technical as you want about the law, he may have done some things wrong. But the only issue is that every single developer that he knows in New York who does the same thing is doing the exact same thing. And the only time people get in trouble is when people don't make money. So now you're essentially saying everyone, because now if you go up to any of the large developers, they'll be in the same position. So unless they're trying to put all retail construction or commercial construction out of business, then why go after Trump? So it's obviously a political thing, and that's my biggest issue with it. Because when you have an attorney general who literally campaigns on, I'm going to prosecute Trump.
Yeah.
That's
when you have corruption right there.
That's it.
I want to point out to you, Joe EV, by the way, when you say air rights, can you say scam without saying scam? I happen to agree with you that air rights are ridiculous, but at the same time, in New York City, in Manhattan specifically, air rights are regularly sold for hundreds of thousands, if not millions of dollars. There's a real value because there's a recognition under the law of air rights as that they are bought and sold every day in New York because in New York all you can do is build up. So the opportunity to build up in New York is no different than the opportunity to sell land in North Carolina. It's the exact same thing.
You remember it's another Trump case, the Central Park West case, where Trump wanted to build that super tower on the west side of Central Park, but it would cast a shadow over the park. Mm-hmm. So they said no because of the air rights. They were like, well, listen, you can't do it because if you build it on that part of the park, you cast a big shadow. Yeah. So yeah, air rights in New York, air rights is a very hot topic. But I've just, again, for those of you who don't know the E. Jean Carroll case, you guys got to read. It's really it's so crazy the way they stretched everything to really get. And like when I saw 83 million, I'm like, oh wow. I thought it was because he said it and said it again, but no. It's because the jury said that he didn't blink her, and a judge disagreed with that and said, no, well, you technically did because SA is that, and we're going to allow that to go to the jury. I'm like, what? No, that's not the way this works.
Yeah, although I'll tell you right now, I think that anyone who thinks he's going to have to pay, he's going to end up having to pay a dime, even if he loses on appeal. This is one of the things I'll tell you.
Mhm.
There's a website called Judgment Marketplace. I don't know if they're still open or not. A former partner of mine formed that. It's a concept he had where it's a place for people to sell judgments, because what a judgment ultimately is, I'll explain, you know what it is, but I'll explain to my audience. A judgment gives you powers to use the law to take someone else's money. And you have the ability to sell those judgments. You can sell it, which means then when you sell a judgment, you are signing your interest in that judgment to a third party. When you sell a judgment, do you know? So if a judgment is for $100,000, do you know what that normally would sell for? Take a guess.
For me?
Yeah, if
Usually,
you want to buy,
if you're getting max at it, you're getting 50 cents on the dollar. I know it sells for a lot less than that.
it normally sells for like 5,000.
Yeah. Oh wow! So you're talking about 5%.
somewhere between 3,000 and 5,000 is what you would buy that for
100,000. Yeah.
And what people do is they'll buy multiple. They'll buy like these. They'll buy they'll buy hundreds of judgments together and then try to go after those judgments. And in the industry, what happens is people will buy hundreds of those judgments and basically package them all together, and someone will go after multiple of those judgments, and you tend to make like 17% on your investments because it's so hard to execute.
Yeah,
judgment. And the reason it's so hard to execute is because especially the bigger the judgment is, the worse it is, because it's less likely you're going to see a dime on it. And that's why I'm saying to you, I will be astonished if her attorneys, I saw Rachel Maddow that there was this whole thing. What are you going to do with your $83 million? It's like, you're going to help out like in women's rights or something. And she started talking about how she's going to be buying yachts and buying property in Paris and all this other idiocy. I'm telling you right now, I will be astonished if they manage to execute on $1 million, because he has a judgment against him personally. How much money do you think he actually has his own personal name rather than Trump campaign, Trump corporation, Trump this, Trump that? I'm sure everything. You saw every property he has, like any other real estate magnate. Each property is in its own separate company. So just because you have a judgment against him personally doesn't mean that you're going to see a dime. And I'd be shocked if they do. I think they're going to really struggle to find any of it.
It's the Al Sharpton. So when Al Sharpton, when he got sued for the Tawana Brawley mess, and they were like, well, yeah, you got to pay all this money. And he was like, well, do you own your clothes? No, it's owned by the National Action Network. Do you own your house? No, it's owned by the National Action Network. Well, you're an employee. How much do you make from that? I make like minimum wage. So because all the trips that he goes on, all the food that it's all paid by the corporation. So I was like, oh, so eventually the person didn't get any money because he didn't own anything. He literally said he didn't own the suits on his back.
Yep.
Tailor-made suits.
I'm trying to figure out how to structure that in my life where I own nothing. I'll own nothing and I'll be happy. That's so true.
That's so
I'll own nothing and I'll be happy.
It's the Al Sharpton. He doesn't even own the clothes on his back. Like, wow. But it just is what it is. When he works, the corporation gets paid. It's like, okay.
Let me cover a couple of chats that came in here. I'm not sure what you mean by the angry cat noises, unless you're referring to defense counsel. Have you been watching this trial at all, by the way?
No, this is the kid. I know this is the kid who shot up the school, and the parents are being charged.
Yeah, the parents are being charged. So Jennifer Crumbley is the mother. She's the one on trial right now. The father is going to be on trial in March. They separated the two trials,
which makes sense.
Yeah, and her counsel seems like she's not ready for murder defense or manslaughter defense. She's not that level. So she's like struggling. I was on with David from Making Law Simple, and he was covering this from the gate, and he was like, yeah, at the start of the trial she was like flustered and she started saying, I want to kill myself. This is what the lawyer was saying. Like that's how, because she was embarrassed about how she was like disorganized. I mean, it was so frustrating watching her yesterday. She had the school counselor on, Okay, the school
Mhm.
counselor in this case, the shooting happened on November 30th,
Mhm.
late in the morning on November 30th, 2021.
Yeah, I remember it because I covered
Early,
the shooting.
earlier that morning, they called the parents down to the school because he drew a picture on a math assignment.
Mhm.
And on the picture, I'll show you. I'll show you what this picture looked like. What he drew there, which they found to be disconcerting. This is what happened. Was first he drew this picture. Check this out. He drew this.
Yeah, which is a pretty good picture of a 9mm.
It's actually 6 hour. Yeah, but
It looks like it's. Hold on here. Let me see. I got my. I'm a gun nut, so I got my 9mm.
you can't show that.
Oh no, it's not. It's totally open too, so it's not even there. It's
Yeah,
right
I don't know.
there.
I don't think you can show that on stream. You're gonna get me
Oh, sorry.
yeeted.
Sorry.
Yeah.
My bad. I forgot. Yeah, I forgot it.
That was a water gun that Nate was showing you.
That's true. Yeah, so what a gun.
So, so they saw this picture of the thoughts won't stop help me, and my life is useless and the world is dead. His math teacher saw this, took a picture of it, sent it to the school counselor, and when the kids saw this, he was in the middle of doing his assignment, so he finished up the paper. By the time he was done with the paper, after the picture was taken by his teacher, so he did this to it. This is the modified. He crossed out the gun and the person, and then he put this is a video game. I don't know what RMX 808 is. I don't know what that means, but OHS rocks, which is Oxford High School rocks, and I love my life so much. Harmless act. We're all friendly here. Crossed out the world is dead. It's like he was definitely trying to cover up the fact that he was having problems because he knew that his doodling had gotten the attention of a teacher, and it seems as if he was working very hard to try and make it look like no, everything's fine, but he forgot to cross out the thoughts won't stop. But he writes I love my life so much. It's pretty funny actually. We're all friends here, but whatever. Anyway, so the school counselor Shawn Hopkins was on the stand yesterday, and when he's on the stand, so he was basically talking about how the point is that she was too busy. She had other things, even though she came down to the school, that they didn't want to take her home. They didn't want to take him home, even though. So they're like, so the judge even asked, "Did you ask them to take him home?" And he said, "No, but I said he needs counseling because we were afraid that he was suicidal. He had suicidal ideations." But you didn't ask him to take him home. Just to be clear, you didn't ask them to take him. He's like, no, but normally, that's I was hoping they would. It's like, so you would think that they should have been killing the defense counsel should have been ripping this guy apart. That it's like you failed to identify this. You failed to go look for a gun. Maybe he got a gun they're angry at him. The reason the state is so angry at him is because they bought him a gun. That's really what it is.
Well, hold on. Just all right. So they call the parents go to the school. The police are there because I'm assuming they called the police, right? So the police are there.
Police didn't come.
The police didn't come. It's just the parents.
They don't call the police. There was no contact with the police at this point. This is in the morning when the drawing happens. They call the parents down because of those drawings.
Yeah. And no one ever searches the kid's backpack or anything.
Right.
Yeah.
And the parents, and they also knew that he had been looking up bullets in school the day before.
Oh
like they had, and that he was watching videos earlier that morning of simulated school shootings.
Yeah, but from what I remember, he went back to the classroom because the backpack was still in the classroom, right?
Yeah, so he went back. They sent him back to class,
and
the thought process they had. And to be fair, I don't really blame the counselor because they looked at this and the conclusion they had is he's a threat to himself, not that he's a threat to others.
Yeah.
So they thought like he was, and they figured we don't want to isolate him. We want him to be in an environment with other kids so that he doesn't harm himself. Because part of the reason that he was purportedly depressed is because he had been isolated during COVID. So like, we don't want to isolate him. That's the worst thing you could do. We want to put him around other kids so he can be more social and become part of, stay in the social sphere. That's better for him. Now, they should have checked to see, to be fair, they should have checked to see if he had a gun. especially, you have to worry about the safety of other kids. I
Yeah, but
think
should have isn't the
foreseeable.
standard. Yeah, it's just like should have doesn't work because you're talking about. Well, I'm assuming it's involuntary manslaughter because
That's
they're
correct.
saying yeah.
Yes.
So for involuntary manslaughter, you need recklessness, which is it's foreseeable. Not should have known is negligence.
Precisely.
If you have known, that's thing. So should have known doesn't work. But then how are we at trial then? Because it's obvious there should have known case.
They say gross negligence. That even though that if it's gross negligence, in that case you can be held. That's what the Michigan Supreme Court and the Michigan Supreme Court. I went through all arguments. They were very concerned about allowing this case to proceed. They were asking the right questions. And when I say asking, and I give them the credit, even though I don't like the conclusion they reached, I can recognize that despite the fact that I feel like this was very liberal leanings against Second Amendment rights, at the same time, they were asking the right questions on both sides. They were asking questions of the defense counsel, and they were really drilling the DA. They're like, has any state ever allowed something like the charges like these against parents to proceed? Or are we going to be like, are we be the first ones? Isn't that a little strange that we're the only ones who would be recognizing that there's a basis for a state to go after this? And another question they had, which I thought was a great question, is you want to hold the parents liable because they gave a kid who's a purported threat to himself or to others with giving him a gun. But isn't that really just trying to clamp down on Second Amendment rights? Don't a lot of kids who have access to gun, isn't that therapeutic for them? That they can actually, learn the responsibility of how to handle a gun. Like these are the right questions that the Michigan Supreme Court was asking the DA. That it seems like this is, that this is counterproductive and not appropriate. Now they still came back with the idea that look, if there's gross negligence, if you can establish that there's gross negligence by the parents in that case, and it's foreseeable that this is a likely outcome. In that case, they can be held liable for involuntary manslaughter.
Yeah, I don't like it because it just there's so many problems with this case. All right, so I do understand in some states you have to have the trigger locks and stuff like that, but so even if they do have access, they can't use it. But then it's like if the state doesn't have that, then then like there's just so much wrong with this. I don't know. I don't see this conviction withstanding any real scrutiny. I understand why you go to trial. But I'm thinking even if they're convicted, it goes up on appeal. This should be overturned because I just don't. Gross negligence. I don't know.
I don't know if it's going to be overturned. If they made it this far, I don't know if it's going to be overturned on a legal basis because that's going to be a finding of fact. If there's a finding of fact that there's gross negligence, the appellate court can't overturn that. Once they've given a blessing that that's a possibility. If there's a finding of fact, I don't think the appellate court will overturn it if she's convicted. But what I was thinking is, so you basically want to prove part of your objective as defense counsel is to prove this is not foreseeable. Well, the best person to establish that is this counselor who didn't foresee it that morning. Saw this picture and didn't foresee it.
Yes. That is, and the great part about that is that. The parent is that because you're at the reasonable person, but you're not a subjective. Well, you can make the argument subjective, but when you're talking about criminal statutes, you're talking about the objective reasonable person test. So I can see the argument here. For those of you who don't know, an objective reasonable person is like the court pretends that there's this fictitious person, and what would that fictitious person do in this situation? So that's what the objective reasonable person is. Objectively, this is what reasonable people would do. Then you have the subjective reasonable person. Subjective is the information that these parents have independently, that stuff that they know, would a reasonable person with their knowledge also do the same thing. So now that's where the conflict comes in. Are we talking about from their knowledge, their knowledge of their son, their knowledge of their weapons, their knowledge of all of this? What should they have done versus what should the counselor have done? So I'm thinking that's how the DA was going to argue it. Well, the counselor didn't know that there were blah, blah, blah in the house, that their son was doing this, that this, all this background knowledge that the parents had. So they'll be arguing for a more subjective, interpretation of that. You parents knew all this extra stuff.
But it's so important for a defense counsel to show the jury that the school has liability here also. And the school has exposure here, and they were not charged. And this person's an expert, and they didn't think it was foreseeable. Force the counselor to say, well, I didn't know that he had access to a gun. But then you could throw it back on him and say, hey, okay, you didn't know that, but did you ask? You saw this
Mhm.
picture of detailed drawing. Did you ask? Did you? And maybe what would have happened in this scenario here, Mr. School Counselor, if he didn't get the gun from his parents? Let's say a friend of his got the gun. The parents didn't even know about it. So in that case, now you would feel like you're totally free of any, that you didn't even bother looking to see whether or not he has access to a gun. Didn't take the slightest steps when you see he's looking up school shootings and you see all that. I would have been making this guy cry.
But I would object to that for course of speculation, based on the fact that, okay, because you're well, again, if he's not an expert, he's a fact witness. So I would be like, you're calling for speculation. I would my point to this, because I think you're building up for a real clobber knocker for the prosecution, because the prosecution was going to say, yes, that's all true. But then they're going to go back to, what did the parents know? They knew this, they knew this, they knew this, all that stuff, because what they're going to do is they're going to build up the counselor and saying, you didn't know that they had a gun. You didn't know he did this. You didn't know he was shooting. You didn't know this. You didn't know this. But who did
even
know?
Ask? But you
Yes.
didn't. But you didn't ask.
Exactly. You didn't even ask. But who did know? So it's reasonable for the counselor not to believe that this would happen. But it's reasonable for the person with all this knowledge to do. So that's why. So sometimes it's a double-edged sword where you can build up the counselor's lack of knowledge, but in doing that, you're also saying, well, but this is what the knowledge that the parents also had. So so it has to be like a very fine line there between saying he didn't know any of this stuff, but then they can easily flip that back and say, well, but they did. The parents did. So is it reasonable for them to know all that stuff and come to the same conclusion as the counselor? You know what I mean?
I hear what you're saying, and to bolster your point, because I'm trying to look at this objectively. To bolster your point, there was a text message that after he got caught doing something, I think with the bullets, and they told the parents about it, which was a day earlier. The mother sent a text back to the kids saying, "Next time, don't get caught." So it seems like almost as if she's, I'm sure they're gonna use that to try and portray her as enabling him and giving her blessing to him to violating what the school wants, as long as you don't get caught. And they're really doing their best to try and portray her as a crap parent. Yesterday, early in the morning, they had on, she owns horses. So she maintains horses. They spend a great deal of time trying to fixate on how much attention she pays to her horses. And to me, what bothers me about this testimony is that it's basically, you're damned she's damned if she does and damned if she doesn't. If she's paying attention to the horses, you're a neglectful woman who cares more about your horses than about your kids. If she's neglectful of her horses, well, then you're just neglectful to things that you should be taking care of. And you're neglectful to the horses and you're neglectful to your kids. No matter how she would handle the horses, they're gonna use that against her.
Yeah, you're fucked. Yeah.
So it's like, what do you want? I mean, it's just like, and it just feels as if now that this is, I feel very confident that if this was a black kid with black parents are not charged. Muslim kid, Muslim parents are not going to be charged. But white parent who gives a gun to their kid, now the parents all of a sudden, let's start scrutinizing their parenting. Do I think that she's a crap parent? Yes, I do. Do I think she should be criminally liable for that? No, because if so, I think that there's a lot of parents out there. I think there are millions of parents out there who should be criminally liable for some of the crap that their kids do. Are we going to start going to gangbangers' parents now?
I think that's weird. But I gotta say though, Joe, the part that just hit me when you said it, she sent the text message saying to the kid, "Next time, just don't get caught." That's pretty damning.
Oh yeah, no,
that's pretty damning, because now let's just go back to what you were saying before about the counselor. The counselor didn't know. Now you almost got a conspiracy here. She's saying, well, next time just don't get caught. So now you do so about information that was known to the parents that wasn't known to the thing, and she knew it was even bad, right? Don't get caught. They're putting up a facade for the counselor so they wouldn't be worried. So I think this is this is even getting worse. Don't get me wrong. I understand the slippery slope argument which you're making, but in this case, if those are the facts, then she's in trouble.
That text message to me is the most lethal thing for her case. I think it's a very because it precisely what you just said. It looks like she's like practically in cahoots with the kid to basically ignore what the school wants and do whatever the hell you want. Just don't get caught. And that implies that if she had been asked about the gun, that she would have lied. She's basically telling the kid, if the kid had been asked about the gun by the counselor, lie, don't get caught. That's essentially what she directed him, and that's pretty brutal for her.
That's very close to recklessness. To be fair, it's very
But
close to
but
recklessness.
here's the thing. You know, it's funny. I remember when I was in high school, I actually had a math teacher who basically was like, if I catch you cheating, I will fail you in the class and do everything I can to get you expelled.
Mhm.
So my rule is you're allowed to cheat, don't get caught. If you get caught,
You get punishment, yeah.
I will punish you
Mhm.
very, very hard. But he would always say, sure, you're allowed to cheat, but don't get caught. You're not
Yeah.
allowed to get caught. So I'll tell you, like, I don't look at that as personally, I don't look at it as that's like negligent parenting, but I can appreciate just how terrible that sounds to a jury, that text message, especially in context after the fact. With 2020 hindsight, what happened,
Yeah.
that looks dead. That's awful.
It could be involuntary manslaughter because essentially you're saying I sent this loaded weapon into the school. I knew it was bad. I told them to hide it, and when they told me he was doing this, I ignored it because I had all this background information, and there's a lot of this background, and to the point where I was telling him not to get caught.
Yeah.
Not to get caught doing what? Bringing a gun to school. It just all stinks. Don't get me wrong. I do think if you're going to prosecute a parent for any case, regardless of the race aspect of it, this is the case you tested on.
Yeah.
Because this is the case that gets you enough to say we may have something here.
Yeah.
You know what I'm saying?
Yeah. Yeah. You're right. You're right.
Yeah.
And you're talking about district attorneys in general are continually trying to expand their power.
Yeah.
And basically make themselves as big a lord of the domain as possible. And I agree with you. I think that this is the perfect case for them to come after him. What's interesting thing is they showed an interview that the parents had yesterday. So they had a cop on this yesterday afternoon, and they showed an interview that the parents gave at 3:00 in the afternoon after the shooting.
Mm-hmm,
And the reason they showed this interview is the mother's on the phone throughout. And the reason she's on the phone, here's the thing. The reason she's on the phone, according to her attorney, is she was trying to access information to like go through the phone to show like different text messages and stuff like that.
Mhm.
But here it is, her kid just shot up a school. They're still cleaning up the bodies from the school. She's in a police station in an interrogation room with her husband and 2 cops, and they're talking to her about the shooting, and the image for 20 minutes is her basically like sitting back and like going through a phone. It just looks like she doesn't give the appearance is so gross, where she just looks so aloof and so detached from the carnage that her own son just wreaked. Whereas it's an awful visual for her. There's a lot of badness here, where right now, look, we haven't heard from defense yet, and we're going to hear Jennifer Crumbley. Supposedly she's going to testify, and I definitely
think you have. I think you have no choice to.
But and she certainly, and I'm sure she was probably dealing with a ton of hate that was probably being directed at her immediately, because she has dealt with a ton of hate. So she became an instant social pariah. So that flip of a switch in her life, I'm sure, was something that was really unsettling to her. But the whole visual there is terrible.
There were a couple of questions in the chat about 2 things. So the first thing I want to make sure everybody understands: this case is about foreseeability. What was obvious that the parents were and ignored, right? You have to ignore, and even with gross negligence, you still have that element of recklessness where you have to kind of ignore a substantial risk, right? And that's essentially what they're saying. So it's about foreseeability. Would a parent in their position with their knowledge have been able to foresee this and stop this tragedy? So that's what we're talking about. And then second, people are saying, well, they're charging the kid as an adult, but then they're charging the parents with this involuntary manslaughter for neglecting their child. Well, again, charging him as an adult for those acts, that's really about his mental state. Was he in that moment able to get the requisite mental state to commit these killings, the intentions? But now for the parents are ultimately responsible for their child under state law. So that's what they're saying. Well, even though he had the mental state to do this, in their capacity as parents, did they essentially supervise him in the proper way so he wouldn't have committed this? And this happens a lot with the alcohol, where let's say kids have a party in the house and they drink alcohol, and the parents then have to pay for anybody who gets sick or whatever, and parents can even be put in jail for underage drinking within their property, even though they weren't even there, and even though the kids have done it. So it's really that unfortunate situation. So yes, he can be charged as an adult because it's about his mental state, and the parents could be charged. Well, for instance, if somebody had beat him or something like that, that would they could be
battered wife.
No, the child abuse, because he's still technically a child, even though he's being charged as an adult. So it's I know it's a weird little thing, but unfortunately in this case it is. But I do think however this case wraps up, I think more liberal states are going to be using this as if it does work, it's going to be using this as the predicate to say, hey, listen, this is possible because look what happened here. And I think these facts are so unique that I think it's really going to be hard. I think it's going to be hard for them to get out of this, because if we hear and the jury's hearing all this, juries aren't about just straight up law. It's about emotions. It's about, what did you do? How did you feel? Because a lot of times they'll put themselves in the position of the defendant and say, if I was there, what would I have done? And if she's text messaging, a lot of them are going to say, I wouldn't have done that. I wouldn't have done that.
Yeah. Yeah. I mean, I saw someone earlier ask the question, is there a rule book for how parents of a school shooter should react? And, like thinking that it sounds like a joke. This is what's the right way to act. They have a rule book for parents of school shooters. And that's not, that's not the point.
It's what a reasonable person.
The point is, how will a jury look at it? Just think, like, how is a jury when they see this? And I'll tell you this much: I think they should be accounting the fact that she could have been in shock. She likely was in a state of shock several hours afterwards. But if she's displaying emotion of grief or even anger or just some level of emotion to a jury, whether that grief or anger or crying is related to the children, the victims, or even her own kid, that's something that a jury can relate to. It's much more difficult for them to relate to the fact that the entire community is reeling in shock, and the visual of her spending 20 minutes in an interrogation room just scrolling through her phone, sitting back scrolling through her phone. I mean, it's terrible. You have to recognize that there is no handbook, but when a jury knows how this rocked the community and how they all felt when this thing happened, and to see how the mother's reacting, it just really bolsters the perspective, rightly or wrongly, but it definitely bolsters the perspective that she's completely detached, like a neglectful parent. Right?
But the thing is that you have to look at the whole, like, even that one piece, you got to look at it in the full context. She knew they were playing with guns. She had this text message about, hiding, they don't get caught. And then after the thing happened, she looks, nonchalant, like she's scrolling on her phone. You put that package together and put it to a jury and say, what do you guys think? Is this the way a reasonable person would act?
Yep.
I'm going to say
like a Nate video.
Yeah, I'm like,
you reach your own conclusion. Official Ryan Nevada says, if they're charging him as an adult, but they're charging as a parent, it's because he's a child. Can't the kid's defense use that to help him in trial? He already pled guilty to these charges. He's appealing the sentencing because he got life, and his counsel's basically saying he's a kid, he shouldn't be getting life. But because he was 15 at the time that this happened. I don't know how successful that's going to be, because I think kids have gotten life before.
Yeah.
But but he's already pled guilty, so that's not going to have any impact. But this duality of them charging him and treating him as an adult and yet punishing the parents, a lot of people have pointed to this, and I can understand why. At first blush, this is the first reaction I had as well. It's very difficult for me to understand why you're charging the parent while charging him as an adult. But then I thought about it some more. And let's imagine for a second that he was 20, right? When instead of being 15, and he did this when he's 20. Does that mean that they didn't? Perhaps it's impossible for them to have set him up to be doing this and be found liable. I think you could. I think that they could still be considered liable, even if he was an adult. So I don't know that this necessarily works to shield her the way everyone looks at this. Because I don't know that it's because they're the parent rather than because they provide him with this access. And yeah, there's sort of this quasi-parental state when you're dealing with teenagers where it's like they're under your roof, but how much control does a parent really have of a teenager? And they're in that quasi sort of like a cocoonish state. They're sort of morphing from being the dependent child into being an independent adult when they're in that teen stage. So yeah, I mean, what are your thoughts on that as far as the state getting sort of two bites at the apple?
Well, again, I think for him, it's like, did he do this intentionally? And generally, when a child, the more explosive or the more serious the crime, the more likely they're going to find the kid had the mental state of an adult. Because generally, you can't charge kids with crimes because they don't have that. You're saying like the reason why kids can't have sex with adults, right? They just don't have the requisite mental capacity to be able to make those type of decisions. But sometimes in criminal law, they can. Right? If a child does something like this, kills someone. So I think in that instance, if you look at it from that perspective, then yes, okay, we can charge this child. But now for the parents, it's kind of like, well, because the question here is, could you have foreseen this person under your care, child or adult under your care, doing this and not stopping it in some way?
See, but now the whole key is the reason. I mean, let's think about why there's culpability. Is it culpability because there's a kid under your care, or is it culpability because you enabled another adult to do what they're doing, or you set up a situation? What is the base? We have to sort of think through here, like philosophically, the basis for the culpability, and that's really the question. Is it because you're negligent in how you raise your kid or control your kid, or is it because forgetting about your role as a parent / guardian, but you're just taking another individual and putting them in a situation where they're going to be committing, you're recklessly putting them in a situation where they're going to be harming others. Like that's what you sort of need to. That's what this question ultimately is about when you talk about charging him as an adult and then charging them as a parent.
Well, let's go back to, all right. So as we're talking about for involuntary manslaughter, the key is, like, let's say with the firearm, right? You have you point a firearm at somebody, pull the trigger, and you don't know it's loaded. You think you're just playing a joke, and that firearm goes off. So it's the mental state is that you didn't intend for that to happen. It was essentially an accident, but the situation was so dangerous that someone could have been hurt, and someone was hurt. So that's what gives you the involuntary. Same thing with drunk driving, right? You can drink, it may not hurt anybody at all. But if you do, it's because you created a situation that was just so dangerous that a natural result is that someone gets hurt. And I think that's what the state is essentially arguing here. It's not that they put the gun in his hand, it's that they're saying they were aware, because you have to be consciously aware of a very dangerous situation boiling, this. And because they were aware of this dangerous situation, it could be a kid, it could be an adult, but they were consciously aware and disregarded that risk to the point where they're like, just don't get caught, right? Disregarded that risk, and then someone was killed. So the state is saying they created, the situation was created, they were aware of it, they knew of it, they consciously disregarded that risk, somebody was hurt. So I think in that vein, that's what they're saying. So it could be the kid. They're treating the kid essentially like an object,
right?
And that object hurt other people, and they were consciously aware of it. It's like they loaded the gun and they pointed it, and that was it. So
I think it's an important thing that you're saying there, that they're treating the kids as an object, and that's sort of how they're trying to take out the intervening act element by treating the kid as if he's an object, and that as if he is the gun.
Yes. Yes, as if he is the gun and he's just pointing it at and they're pointing at somebody and that's it.
Or they're recklessly pointing it at someone. That's a really interesting and important way to try and wrap your head around this whole charge, and how the defense should be looking at it as is, were they reckless with this gun, the gun being named Ethan?
Yes.
Under the same logic, do you think that we can charge Alec Baldwin's parents?
But they weren't there, right? They would literally have to be there, or they'd have to be.
They created
somehow,
Alec
right?
Baldwin.
By creating him. But I think here they had that stupid text message is just crazy though, because it's the text that text message is the thing that's going to get her convicted, because that's going to show she was aware of the risk and she disregarded it. Matter of fact, she even told him to be more careful, so nobody else can evaluate the risk. That then gives the counselor the all right. So the counselor, because she was hiding it, right? She was actively hiding it from the counselor. Don't get caught. Be more careful next time. So the counselor won't. So the counselor and school officials won't know. So I think I don't know. I think she's caught. I think they got her. I think they got her. But I think legally, I think this is still problematic. I think it's very problematic.
I mean, but I think this is an important point that that Dr. Mimo is making, which is that the text really, it's not about the shooting. I mean, when you're saying like, hey, it's not like there's a crime. It's not like she said that when she saw him doing something criminal, right? In other words, what was he doing? He was looking at it's against school rules to look up bullets while you're in school. That was considered, the counsel testified yesterday that's against school rules, but that's not like there's a crime in it. It's just there's no crime in looking at bullets. It's not like he was pulling up CP or something like that. And so it's not like he was doing something criminal. She was just like, she basically is looking at as like, look, this is a stupid school rule that even though it's something completely legal, you can't do this. You're not, even though it's something 100% legal, but you're not allowed to do it in school. So if you're going to do something that's against a school policy, but not illegal, that's where she's giving her blessing. Not that she's like totally like, oh, it's totally fine for you to be a crack dealer. Just don't get caught. That's not what she's saying. She's like, look, this is a stupid school policy. Don't get caught. And that's what I could see. I'll tell you right now, I could see some parents saying the same thing. Like, look, they have a stupid policy. Don't get caught breaking their stupid policy.
But again, I'm going to say this entails what they're trying to show is that you have to show a conscious disregard of a substantial and unjustifiable risk.
But
that's what they're trying to show. He owns a gun. Him looking at bullets.
I'm
not saying it is. I'm just saying the standard is it's a conscious disregard of an unjustifiable risk. And they're saying that the unjustifiable risk was all this. Everything you're saying was just part of the risk, and they were aware of that unjustifiable risk. So I think you're right, but I do think that's the standard that they're trying to overcome.
Walter Melons asking Nate, under those standards, couldn't the state go after the parents in gang drug crimes, or is there a difference?
I think, a lot of times, especially, and Joe knows this, when you're talking about law, people always think there's like this one blanket rule that you can just say about every case. But every case is because the law talks about contextualizing each set of facts based on the law, not just one general all-out principle. So in this particular, yes, in some cases, right? If the parents know that the kid is selling drugs, the parents know that, and the parents are actively involved in it, like with this, then yes, this is saying that could possibly happen. If the parents, here the parents knew the kid had a gun, encouraged it, don't get caught with the gun at school, that type of thing. That would, if you can equate those same facts to a drug situation, the parents are, they're selling drugs, know this, and somebody has an overdose, then yeah, you can say the parents caused that by creating a substantial and unjustifiable risk. They were aware of it and consciously disregarded it to profit from it. And I think their motive would be profit. So yeah, I think you could do the same thing.
All right. Oh no, what did I do?
And I think people also don't realize too, is that juries, like people like, she was just using a cell phone. She was just doing this. You can't just look at that one event and say, is this make it guilty or not guilty? It's looking at that one event, but in the context of everything else, in the context of the whole thing. And the shooting is the end. We're looking at everything before the shooting is trying to tell us a story of whether a reasonable person would have also realized that there was this risk involved.
I think I might have just screwed up in locals and deleted this the post for this. I think I might need to repost it.
Oh,
I think I screwed up in locals. So those of you who follow me or do my diggers, I'm going to remedy that now.
but I also think this, but I do think this case is so it's so dangerous because I do think it opens up a Pandora's box. I think it does. And the problem is that when you're fighting for your life at the state, just hundreds of thousands of dollars to keep out of jail. So
Yeah. It looks like they're waiting for the jury to come in here.
yeah.
Lost in Law says, Mr. Not Leader, I appreciate your help in securing digging tools, but I must wonder how you got a shovel made completely of gold. It's not completely. It's 14 carats.
They're still messing with you about the Jew tunnel, right? The Jew tunnel.
The Jew tunnel.
The Jew tunnel.
See, you can have a Jew tunnel, just don't get caught. Just don't get caught.
Don't get caught with the tunnel. Oh, matter of fact, yeah, let me show you. Let me show you this. This is what I found about the look at this. So this is the article on it. It's hilarious. I still don't understand. So here is the article from Business Insider. See, Trump fights to keep the blank word in E.G. Carroll. Now, this is it, right? So his lawyers plan to argue that since the jury has now rejected her blank claim, Trump rightfully called her a liar. And that's true. That's all true, right? He said she's lying. I didn't blank her, and the jury rejected it. And you know what the judge said? No. This makes no sense to me. I just don't understand it. I don't understand it.
Make it make sense.
Does that make sense to you? I'm trying, because you know me. I like to try to see from both sides. But if the jury says you didn't do it, and you say she's lying, I didn't do that, then why am I paying $83 million for defamation?
It's unbelievable. It's really unbelievable.
That's literally what happened. This is what happened, and nobody's talking about that. No one is talking about this aspect of it. No one's even talking about it. No one's talking about it. I'm the only person. It seems like, you know how long it took me to look through all these court documents to find this stuff. I was like, why isn't anybody? This doesn't make any sense.
Yeah, I've been talking about it, but people see. Here's the thing: no one listens to people on my side of the aisle when it comes to defending Trump. It's like they just sort of like zone out. But like when I was in Spaces, I was talking about that. But then here's the thing: I actually feel yesterday I got reassurances that people actually hear me in Spaces. You want to see something cool?
Cool.
Check this out. This was on yesterday. Oops, I'm gonna do this over here. I'm gonna make this. We'll go over here. This was on yesterday's PBT podcast.
Oh, PBT. I like PBT.
Yeah, check this out.
You did a Twitter live the other day, and someone by the name of Good Logic.
Oh yeah,
he was a speaker, and he said that he's hoping that Trump takes a more positive approach in his campaign this year. More positive, a little bit more relaxed in his visceral towards
the media and everybody,
ferociousness towards everyone, right?
Yeah.
And I agree wholeheartedly. I think very similar to what I call Tate 2.0. He was so boisterous to a point with certain beliefs, with certain.
I give credit to this guy. I give credit to this guy. This is with PBD. I don't know who this Mike Majlik is.
No. This is when you were in the Mario.
Yeah, one of Mario's. Right? Yeah,
and you should be thankful. I hooked you up with the Mario Twitter Spaces too. You see now, Joe is being on PDP. He forgets me.
Yeah, I've been on Mario Spaces a bunch. I like hanging out there. I think it's great exposure. So
I'm the one who got to it. Yeah, I'm like, yo, Mario, here it is. This is Joe. Yeah. Because remember, I was on there. No, actually, it's Viva who was on there. Then Viva introduced me. Then I was like, yo, Joe wants to get on here.
I'm really amazed that this guy remembered. Normally, most people in this guy's circumstance would have just said somebody said
on Twitter.
They would not have remembered the name Good Logic. So yeah, I'm very appreciative that this guy Mike Majlik actually called me out by name. That's doing me a real solid there with that.
Yeah, but the thing
So-
is that people also, one thing I do know is that number one, they've called you the lawyer on the eyes. I see like they message you. I want to talk to the lawyer. So you're the lawyer now on the spot face.
Yeah.
But number two, you make good points. And if you make
Thank
good
you.
points, sometimes we want to make sure you let the person know, like, hey, listen, this is the person who made these good points. Because that wasn't the only one good point that he probably thought you made. He probably thought you were talking sense. So he probably wanted to make sure to give you
Right.
some credit. Yeah.
This is the it seems like they're starting to come back in now. Seems like things are happening now. Hopefully, Joe, we're offended by being called diggers. We took a vote. It's dirt removal technician. Don't
Oh
let
my
it happen
God.
again. Yo, my digger. Yo, what up, my diggers?
Everybody's doing like there's so many different trials going on. There's the murder stuff. There's this. There's that. There's like everything going on.
I was
So-
bouncing yesterday. I was like, I really wanted to watch the Murdoch thing. I ended up streaming this yesterday all day, and then spending 3 hours going through the Murdoch hearing last
Ooh.
night. Tonight I start my 24-hour stream.
Oh yeah. I'm just gonna mess with that tomorrow. I'll be on it tomorrow.
Yeah.
It's gonna be good luck with that, brother. That's gonna be tough.
Thank you. Yeah. I'm gonna try to take a nap. That's why I'm like, I don't expect to be streaming this afternoon. I think I'm gonna be taking a nap this afternoon. And
I think Uncivil Laws is streaming it too, though. So I'm not even sure if he's doing it. I think him and Alita too. Legal Bites. I
is
haven't
she
seen her
covering
in a
this
while.
too?
Yeah. Oh well, I see Uncivil is covering it, but he hasn't started yet. He think he's doing it at 1:30.
Okay.
And let me look at Legal Bites because I saw her. She was doing some of it yesterday. No, she's still on her classic trials. The Menendez. She's on episode 56. I don't know who's watching those classic trials. That's a slow burn right there. Like boy.
That's dedication to the cause.
I'm like, what the hell? Yeah, she loves those. She loves that classic trial. But that's like if you're at episode 56. It's like, my God.
Yeah.
But I think it's a Johnny Depp thing too, because everybody thinks the trials, but nothing's like Depp. Nothing's like Johnny Depp.
Mm. So you haven't been hanging out with Legal Bites recently?
No, I haven't. I'm to be unfair. You're probably one of the few. You and Eric on the few live streams I do. I really don't live stream anymore. I do my produced videos because I like.
But
to
you're
do the
killing
research behind
it. You're killing it. By the way, you guys need to check out if you're not subbed up to Nate yet. You really need to check out his work because one of the things I really like about it is that I know. Look, out of everyone in this sphere who I hang out with, he's probably the most controversial one. But that's because he speaks his mind and he's not afraid to basically say, look, I'm assessing this set of circumstances based on what I know about the law and the facts that we see and that are provable. And here's how I come to my conclusion. And it's not directed. It's basically just taking everything like a floating bee that wherever the wind is carrying me based on that's what I look at Nate, that he basically, wherever the facts and the law leads him, that's where he's going to be. And it's very detached from any ideology per se. And that's something that I give you a great deal of credit for. And you do a phenomenal job putting it together.
I appreciate that. But I always feel funny is that when like, for instance, Rittenhouse, like when I agree with the left side, I'm like this wonderful minority lawyer who's fighting for the poor man and, this, diversity. But then when I disagree with them, I'm a coon who's a race traitor. And I'm like, listen, I'm just looking at like Kyle Rittenhouse. I was a race traitor, Trump supporter, blah, blah, blah. But for Chauvin, I was like, oh, he's just with us. So it's like, because again, I just look at the facts. I'm like, it's clear Kyle Rittenhouse is like, how could it not be? You couldn't have gotten a clearer case of self-defense if you wrote it in a book and just said, how can I make it as self-defense as possible?
And the scary thing is that if there was no video, we never would have realized just how innocent he was. Yeah,
he probably would have been convicted. So, and I think that's sometimes what has to. And again, the reason why people watch me is because They don't know what I'm going to say. Well, in case they don't know what I'm going to say. But what I can do is show them why I'm coming to that conclusion. And Joe does the same thing too. You do exactly the same thing. Here's the reason why. Like when I read through the Trump case, you're like, here's the reason why I'm coming to my conclusions. And I think that's the best we can all do.
Right. See, I know I'm seeing why I made this mistake. The reason I think I made this mistake is because on my thumbnail, I forgot to change day 3 to day 4. That's why I made this mistake.
Oh, yeah.
That's what I did. That's what I did wrong. That's what I did wrong. My thumbnail is screwed up, and I confused myself with my own stupid thumbnail.
Oh no, what's his name? He's on too now. You guys are all my live streaming brothers. What time are you starting today for your 24-hour?
Midnight.
Okay. I don't know if I'll be on at midnight.
No, but anytime tomorrow. Just pop in. Anytime. I'll send you out links.
I actually got to go because I got a meeting. I forgot I had.
Okay.
I'm like 15 minutes late for it. Shit, I'm having so much fun here. I'm like totally forgot. Later,
Joe,
chat.
Later, brother. Thank you so much. I'll see you tomorrow. Just be sure you want the nitrogen gas in Tunnel 3. I guess cheaper than if it's your independent contractor. Yes, please make sure. But make sure that you use the PVC piping. Okay, not the iron. That's way too expensive. It's a nuisance to deal with. Nate is civil about it if he's controversial. He is civil. He's like, tell me where I'm wrong. I don't always agree with his conclusions. I will frequently argue with him, but it's always meant with respect. So I did. I'm figuring out what happened. I screwed myself up by neglectfully failing to change day 3 to day 4. And I identified them by changing. What I try to do is when I'm covering multiple, in case you're wondering about the method to the madness, when I'm covering a trial, so I'm going to have like a similar thumbnail day after day, but I want to be able to identify them differently. So I'll try to put in the morning and up to whether it's a morning or afternoon, I'll try to put that in the corner and I'll change the color of the font for that stream. So I knew that this morning I was using this green shade. Yesterday I used purple for one and blue for another, and try to change the color of the font. So this way it'll sort of stick out as being different and identifiable that this is, it's not that stream, it's this stream. I really do need to change. I need to change the, it's terrible that I wrote day 3 where I meant to write day 4. That's really bad. This is not me on the volume. I can't believe that they called trial for 8:30 in the freaking morning and it's 10:18 and we haven't had a witness come up yet. I mean, this is just a cluster of just disaster. I mean, seriously, you call this for 8:30 in the morning. It's almost 10:20. It's almost 2 hours that we're here. I'm not disorganized. I try to be organized. This is where, see, I meant to do, I should have done this day 4. Gosh, I'm going to change my thumbnail. Day 4 morning. That's what I need to do. You'll get to see how the I gotta change my thing. I know you're saying no one was wondering, but to the handful of people who basically are OCD or paying attention, it makes it easier for them to like find the right stream. So it's kind of relevant for that. So that's why I sort of, it might not be your thing. It might not be your thing, Debbie. Why am I requesting a review that this is not, the gun. I'm not even going to try to request. I'm not going to request a review of this one. I don't know what they're going to do if they see that thing. Neat. Like he's never live streamed before. All right, I changed it now. So at least people recognize that it was day 4. Hey, you can give us some volume, Law and Crime, now that the jury's coming in? Oh. Thank you. All right, I updated my thumbnail on both YouTube and Rumble. So should be good now. Should be good.
All rise for the jury.
I wonder how that got started, the notion of rising for the jury. What's with those stockings that the defense counsel has?
No, you need to see it. You guys okay with Pat over there?
Yes.
Yeah, okay. Good. Prosecutor, who's next with this?
Mr. Nicky Jack.
Sorry,
Probably not.
Nick Ejak.
Meet Nick Ejak.
Oh, I want. This is another counselor. This is an important one. This is an important one. This is the guy I really wanted. He's the other counselor from the school. I think he oversees discipline.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth so help you God?
I do.
Please step up and have a seat.
This is her chance to redeem herself.
And then can you state your name for the record and spell your first and last name?
Sure. Nicholas Ejak, first name Nicholaas, last name Ejak, E-J-A-K.
Go ahead, prosecutor.
Thank you.
He certainly didn't get any. Wasn't mocked for that name.
Sir, I want to direct your attention to the fall of 2021. Where were you working at that time?
Oxford High School.
Okay. And what were you doing there?
I was the dean of students.
How long had you been employed at that time with the Oxford School District?
That was my first year.
I'm sorry?
That was my first year.
Okay. And you're with a different school district now?
Correct.
Okay. Tell the jury, please, what exactly the Dean of Students at Oxford High School did.
So the dean of students is responsible for all of the student body, behavior, discipline, attendance, academic intervention, behavior intervention.
Okay. So walk us through a typical day as the Dean of Students at Oxford High School, at least in the fall of 2021.
Sure. So in the fall, also, we were, in 2021, we were dealing through the COVID-19 pandemic. So in addition to those responsibilities, due to the health order, part of my responsibility was ensuring that everybody was masked up. So that was part of the job throughout the day too, was to ensure students had access to masks, but they were also wearing them. Students were referred throughout the day from teachers based on behavior they're seeing in class, students coming down to report stuff going on in the building, conflicts they're having, conflicts they're hearing about, attendance issues where kids aren't coming to school or they're showing up late frequently to class. At the time, we didn't have an attendance policy coming out of COVID. So that was also part of my responsibility, was to put together a policy that would work for the school.
Okay. So yesterday we heard from Shawn Hopkins, who was a school counselor, and he said that there were 4 counselors. How many Dean of Students were there?
1.
Okay. So will the responsibilities of a school counselor differ from the responsibilities of the dean of students?
Yes, that's correct.
How so?
So counseling, they oversee, to my understanding, they oversee college and career planning, class scheduling, mental health of the student body, planning events in relation to like extracurricular activities, the Oakland Schools technical campus. There's a lot of responsibilities that has no relation to the dean of students role.
Okay, so if I'm understanding you correctly, you would be called in when there was a discipline problem in class.
Correct. That was the main function of my responsibility.
Okay, and as you said at that point, the county health
He enjoys
department
torturing.
mandated masks, or is that the state order?
I believe that was Oakland County.
Okay, and so it was your responsibility to also mandate compliance with that.
Correct.
Okay, so November of 2021, all students and staff were wearing a face mask.
Correct, with the exception of anyone that had a medical exemption.
Okay, thank you.
He looks like he has his
Now,
two-thirds of the way
how
towards
long have
building
you
his
been
own
in that
personal
role as of
dungeon.
November of 2021?
That would be 4 months.
Okay, so when you started that school year?
Yes.
All right. And where did you work before? What did you do before?
So prior to that, I was a long-term substitute teacher for Lake Orion schools. Once again, coming out of COVID, I had been laid off as the dean of students out on the west side of the state, where I was running an alternative high school program. And so I had returned to this side and was able to obtain employment as a long-term substitute.
Oh, they call this hair
With the
Comic-Con
idea that it would be temporary
hairstyle.
for that school year.
So in November of 21, how long have you been in education?
That's not me. That's not me. That's law and crime. Stop sucking, law and crime. But that is called the hair commandant.
Where data on students is stored and accessible for teachers, administrators, students, and parents. Everybody has a different view of that, but it's the same system. So if you're a parent, there's a parent view where you're able to see specific things to your child as a parent. For students, it's the same thing. You can see stuff for your students, which includes your grades, missing assignments, and then like my view as a part of the school staff administration would be able to see all of that.
Okay.
And input information to that as well.
And as an administrator, you're able to input, is that what you said?
Correct.
Okay. And that came with every student in the district, would that be right?
Correct.
That was Jennifer Crumbley's son, a student at Oxford High School in the fall of 2021?
Yes.
Okay. Prior to November of 2021, did you have any interaction with him?
I did not know.
I want to direct your attention to November the 29th, 2021. That's a Monday, the day before the shooting. Did you receive an email regarding Jennifer Crumbley's son?
I did, yes.
Okay, I'm going to direct you to the screen that's in front of you. This was admitted yesterday as People's Exhibit 158. This is an email to you and Ms. Pam Fine.
Correct, yes.
Okay. It was sent from whom?
From Jacqueline Gabino.
In
Seriously, law and crime. So the real question from defense counsel is, why didn't you ejac him out of the school?
Passing out their essays. I didn't get a chance to investigate it a bit further since it was the end of the hour. Now that he's on my radar, I'm also noticing that some of his previous work that he's completed from earlier in the year leans a bit toward
Violent side. I can bring down these
today during my 5th hour prep if you would like them.
Okay. And this email was sent at 9:32 a.m. to both you and Ms. Fine. Please give the jury an idea of who Ms. Fine is and what her responsibilities were at that time.
Sure. So Ms. Fine is the restorative practices coordinator and the anti-bullying coordinator for the district. However, her position is housed at Oxford High School, but she does work in.
Okay, this is not working for me. This is really not working for me. I'm gonna see if I have a better feed.
Throughout the school.
Okay.
So that's why both of us were
Okay.
sent this email.
So when you received this email, what did you do?
So by the time I had actually,
Well, let me ask you this question. If you recall, when did you actually receive the email? When did you actually read it?
when I received the email, it was probably around 11 a.m. when I
Okay.
was aware that there was an email.
And tell us what happened with this situation.
So when I was made aware of the email, it was coming from Miss Fine, who had overheard me returning to my office from a meeting that I was in when this email was initially sent.
Your office was in the administrative section of the Oxford High School?
Yes.
Okay.
My office was right next to hers.
Next to Miss Fine?
Correct.
Okay.
And so we often would just like kind of yell out if we needed to talk to one another, and then one of us would walk over to the other's office.
Okay.
And so she had heard me returning to my office, and I remember her saying, "Hey, do you remember that email we got today?" And I said, "What email?" And then that's when I had walked over to her office and pulled it up on my phone, and she began to explain to me that she had read the email and knew that I was in the meeting, and I believe she even responded, got it to the teacher,
Okay.
and walked me through the steps she took, which was calling the student down.
Mr. Hopkins was with Miss Fine in the meeting, correct?
Correct.
Okay.
Yes. The meeting had since ended, and so like she was just walking me through what they did.
Okay. So she updated you on what happened in the meeting?
I'm sorry, what?
She gave you an update on what happened in the meeting?
Yes, correct.
Oh, for the love of God. Why do you suck so much long crime?
Did you determine if you had to take any steps?
Wow.
That I did anything further. She did everything that I would have done.
All right. Did you have any additional interaction with that student at all on Monday, the 29th?
No.
Okay. Now, moving towards, did you receive any emails later on in the evening, Monday, the 29th, regarding the student? Anything at all with him?
I don't remember if I did or not.
Okay. November the 30th, Tuesday. This has already been admitted on your screen here as People's 160. This is an email from Miss Morgan. And who is she and what does she do?
Miss Morgan is a math teacher at Oxford High School.
Okay. So she sent this email to you as well as Mr. Hopkins Tuesday, November 30th at 9:32 a.m.
Correct.
Okay. Up until this point in time, did you have any conversations regarding Jennifer Crumbley's son?
Prior to this email?
Why do we have
Yes.
Okay, tell us about that, please.
So I was in my office Tuesday morning when Miss Morgan had walked down to the front office.
Why is the video and audio is
Share
not synced at all?
that had drawn inappropriate things on a piece of paper, and I was the only person available to respond to that or to hear her out.
So let me ask you this. This is People 74. It's already been admitted.
We'll be
You sent
arrested.
a piece of paper. Is this what you're referring to?
That is correct.
Okay. So prior to the email at 9:32 a.m., Miss Morgan showed you this, which has been admitted as People 74?
She showed me an image of that on her cell phone.
On her cell phone. Okay.
Yes.
Do you recall about what time that happened?
I don't know.
Okay.
I just know that it was during our second period of the day. However, I don't remember what time.
Okay, that's fair.
That was.
Tell us about that conversation when she came and showed you this picture.
She had said she just needed to share that a student had written some inappropriate things on an assignment. And so I told her, I kind of waved her into my office since everybody else was occupied. And she had turned her phone around and showed it to me. And I had noticed the name on the top that I recognized from the day before. Miss Fine had shared that information with me.
Seriously, with the lighting?
My response to that was, I need to go get his counselor.
The mustache
And
looks a
her
little
response was,
different.
I need to get back to class.
Okay. So that was in the second hour, you think?
Correct.
Okay. So obviously it was before the email sent at 9:30.
Yes.
All right. Now, what was your initial response in seeing this Exhibit 74?
That I needed to alert his counselor.
And why is that?
Because it seemed like he might need somebody to talk to, or we might need to figure out how we could get him some additional help.
Okay. Now, when you first looked at this drawing, what's the first thing that jumped out at you?
The statements.
Which
The
one in
blood,
particular?
blood everywhere is what I noticed first. The world is dead. My life is useless. Those were the things that stood out to me.
Okay. So when you were shown this, were you thinking of a lens through discipline or through his counselor?
Counseling, 100%.
Why do you say 100%?
Because I don't notice anything on there that would rise to the level that there would be any type of student discipline.
Not
So
a threat
what
to
happened
others.
next, please?
That's what the
So
defense has to hit
she
on.
left Miss Morgan left my office, and I left my office.
You should be writing big letters here. You identify him as not a threat to others.
Mr. Hopkins.
Okay. And did you show this drawing to Mr. Hopkins?
I did not.
Okay. Did you? When you say you alerted him, what do you mean?
So when I arrived to the threshold of the doorway in his office, before I even said a word, he said to me, "Ethan Crumbley," and my response was, "Yeah, how did you know?" And so he shared that he had received an email that morning from another teacher regarding Ethan Crumbley, and his understanding was that's why I was there, and that's when I had shared with him that I had received a drawing from Miss Morgan with those statements on it.
Okay. This drawing right here, Exhibit 74?
That is correct, yes.
Okay. Now tell us what happened next, please.
His response, Mr. Hopkins' response to that was, "I'll go get him from class right now." And he stood up from his chair and walked down to the math class and grabbed Ethan.
Okay. Did you go with him or did you stay?
I remained in his office.
Okay. And did Mr. Hopkins bring him back to his own office?
Yes, he did.
Okay. And what did you do?
I sat in there and mostly listened to the conversation.
Okay, let me stop right there.
Sure.
So, just so we're clear in the chronology, Mr. Hopkins retrieved the defendant's son from class, brought him back to his office where you were waiting.
Correct.
Okay. And then was a conversation ensued between Mr. Hopkins and the defendant's son?
Yes.
Okay. Now, he testified yesterday, so without telling us what words were actually said by each other, tell us what you did and why.
I just sat there to listen for one, to be an additional adult for support. I feel it's important in my job to know that there's more than one adult in the building that cares about the students. And so it was important to me that I was there for support, but also there in case there was a reason that there was behavior that rose to the level for discipline.
Okay. And during that initial conversation, did your opinion ever change to look at this as a counseling lens or a discipline lens?
No, it did not change.
Was a decision made to call that student's parents?
Yes.
Okay. And who made the decision?
Shawn had made that decision.
Okay. And were you there when he made that phone call?
I was, yes.
And we have evidence to suggest it was at 9:24 and 9:27 a.m. when phone calls were made. Does that sound right to you?
Yes.
Were you in the office when the calls were made?
I was, yes.
Okay. Were you in the office when a portion of the phone call was on speakerphone?
I was, yes.
Tell us what you recall from that conversation.
So I recall Mr. Hopkins putting the phone on speaker so that the conversation could be had collectively. And so Shawn Hopkins had introduced myself and said we were there with Ethan. And during that conversation, he had forwarded the email that we got of this assignment to his mother.
Is that the defendant, Jennifer Crumbley?
That is, yes, correct.
Okay.
So that she could see it in real time while we were having the conversation.
Okay. Did the defendant make any statements regarding that?
I believe she said, "What were you thinking? Why did you do this?"
Okay. And that was while on the speakerphone where her son would be able to hear it?
Yes.
Okay. Were you there when, well, at some point, the defendant and her husband arrived at the school?
Correct.
Okay. So in the time period that elapsed from that phone call to the time period when the defendant and her husband arrived at the school, what did you do?
So once the conversation had ended, we had already changed class periods and it was now our third hour of the day. And so his backpack was still remaining in the math class. And so it's a common protocol that our security or a hall monitor or someone will go retrieve the student's belongings if they're still waiting on a parent meeting or still having a conversation. That way it's not left when other students arrive.
Okay, so what did you do?
So I left Mr. Hopkins' office and walked down to Miss Morgan's classroom to retrieve his backpack.
Okay, and did you give it to him?
Yes, I did.
Okay. At that point in time, with the COVID protocols in place for students using lockers?
None.
I have a different feed that I'm going to just switch over to that I think is better. I'm hoping is better.
That way it's not left.
I'll change the volume.
Okay, so what did you do?
So I left Mr. Hopkins' office and walked down to Miss Morgan's classroom to retrieve his backpack.
Okay, and did you give it to him?
Yes, I did.
Okay. At that point in time, with the COVID protocols in place for students using lockers,
Not at all.
okay, so every student had a backpack with them at all times?
Every student had a backpack.
Now, what was your expectation of what was to occur at the meeting with James and Jennifer Crumbley at school?
So my understanding is that we were going to discuss what would be best to move forward next for getting him some additional help, and that would be happening that afternoon.
Okay. As in happening that afternoon, what does that mean?
That he would be leaving from the parent meeting with his parents.
Okay.
I'm getting a little bit of a Patrick Bateman vibe with this lighting.
Were you in the counseling office during the meeting with James and Jennifer Crumbley?
For most of it, yes.
Okay. And who led the meeting primarily?
Mr. Hopkins.
Okay. Tell us a little bit about how that meeting progressed.
So when I arrived, Mr. and Mrs. Crumbley were already in his office, and they had already began talking about the events that led to the parent meeting. And the edited drawing.
Yeah, you said, so this is exhibit 123. So this is what you're referring to as the edited
That
drawing?
is correct, yes.
Okay.
That was on the table because Mr. Hopkins had retrieved that from the teacher when he went to get Ethan from class.
Okay.
So that was on the table and for them to view, although, like I mentioned before, Shawn had emailed a copy of the original document to Mrs. Crumbley. And so they were kind of discussing what was next, and she had a pamphlet or a packet of resources that the district provides.
So who gave her that?
Shawn, Mr. Hopkins.
Okay. And we say resources, what do you mean by that?
Different counseling resources available in the area, and it's like a standard packet that the school district would have on hand to provide to anybody.
Okay. Have you been involved in meetings where that sort of information has been provided to parents in the past?
Yes.
And you said it's a standard list of information or
It's just a
resources?
general list, yeah,
Okay.
of stuff in the surrounding local area.
Does that include facilities or organizations that allow same-day counseling appointments?
That I'm not sure of.
Are you familiar with Common Ground?
I am familiar with that.
And what is that organization?
So that is, they offer a couple different things. So they offer mental health resources. You can call a hotline to speak to somebody. You can even go there for like day of intake screening assessments. And that is the organization that in previous districts I worked in, that a lot of students that have been seen for mental health had went to.
Okay. And they're here in Oakland County?
Correct, yes.
All right. Now, clearly your expectation of what was to happen at the meeting was not met. Tell us about that, please.
So throughout the conversation, I had overheard his parents confirm the things that Ethan was sharing with us in his office that were kind of explaining the drawings and the words that he had written that supported him feeling sad. And so he had shared that a dog had passed away recently, a grandmother had passed away, and then one of his close friends had moved within the last month or so. And then that he was very interested in designing video games, and that had led to a argument the night before that he should be more focused on his academics rather than the video games.
Did she provide any details about that argument?
No.
Okay. Did she provide any details about how the circumstance in which when his friend moved away?
No.
I'm sorry, please continue.
None of this is very damaging to the mothers.
He really struggled through the pandemic with the virtual learning, as many students did, and that they felt like he should put more focus on his academics than spending time working through the video game design.
So at any point, did you see this as anything different than your initial perception, which was a mental health? Okay. You said you had the backpack with you and you provided it to the student. Okay. At any point, did anybody request to search the backpack?
They did not.
And did you search the backpack yourself?
I did not. It wasn't necessary or rise to the occasion that I do that because I didn't have any reasonable suspicion to do that. And I did that.
Explain what that means, please.
Sure. So reasonable suspicion means that there needs to, by law says you have to have some type of reasonable suspicious activity to do the searching student belongings. And So typically that's like a report that someone has a vape pen or a weapon, or that they're
Vape pen or a weapon.
something they're not supposed to have at school.
The same thing, pretty
or
much.
Nervous behavior when you have their belongings, which is very typical of students that we have searched in the past. They usually, their behavior will change when you're in possession of their stuff. And none of that was present at that moment.
And again, it's a lot of details. Well, have
Some
you
of
ever
it
met the
Trying to give a
before?
pass to himself for not going through
You
it.
ever met her husband before?
I have not known.
Prior to this day, you ever met their son before?
I did not know.
Okay. And was he wearing a face mask the entire time?
This is their justification for why they didn't go through the bag.
Now, was there a desire for him not to be
Why not
left
ask
alone at this
Yeah,
point?
it's done.
That's what Shawn had stated during the meeting when we were discussing what to do moving forward. And so his recommendation was that Ethan receive outside counseling as soon as possible today, if possible, meaning the 30th.
Mhm.
And the response to that was, we can't take him anywhere today. We have to go back to work.
And who said that?
Mrs. Crumbley said that.
The defendant did?
Yes.
Okay. What was your reaction to that?
It seemed a little odd based on my experiences in previous similar parent meetings when students are being seen for mental health.
Tell us about that.
Could you rephrase that? Tell us about
So
it.
why did it seem odd to you?
Because typically,
Your Honor, objection as to relevance, what he's experienced with other parents.
Overruled.
Just it's similar to Mr. Hopkins' testimony yesterday. You can lay a foundation that he's been in these meetings before.
Go ahead.
So, sir, you've had the opportunity to be in these type of parent meetings before with mental health issues?
yes,
Okay. And could you put a number for the jury and how many you've been a part of?
between 5 and 10 of them
Okay.
across the time of my education.
Okay. So calling in a parent for an immediate meeting, that's not a regular thing that occurs, correct?
It is not.
Okay. So that's something that something has to cause the school administration to do that.
Correct, yes.
Okay. Now, you testified earlier that it was your expectation that the defendant or her husband would take the defendant's son home, correct?
Correct, yes.
Okay. And this did not meet your expectation, but you found it to be odd. So comparing what happened November the 30th with everything in your prior experience, tell us why you felt that to be odd.
Typically, when it's recommended that parents take their children to seek out medical assistance immediately, they follow the direction of the mental health professional, and that's been my experience every time.
In this case, that would have been Shawn Hopkins.
That is correct, yes.
Now, what was your impression of how that meeting ended on the 30th?
It sort of seemed like it ended abruptly. It was a very short meeting. I want to say it was somewhere near 10 minutes long.
Okay.
And once it was determined that they were not going to take him home.
They didn't ask him to
it was
take him
stated that
home.
He would end up having to walk home if he was going home and then be home by himself.
And who said that?
Ethan had said that.
Okay. In front of his parents?
Yes.
Did either Jennifer or James dispute that?
No, they didn't.
Okay. Please continue.
And that's when Shawn had responded that he really didn't want Ethan to be home by himself alone. And that he thought it was best that if he wasn't going to leave that morning.
This is
with
new.
His parents, that he remain in school so that he could be.
Now we're blaming the parents for
He
him
would monitor his attendance and check in with him.
pushing for him to stay there. That's not what Hopkins said yesterday. Hopkins said that Ethan wanted to stay, not that the father was.
I've nothing further.
Stay.
Cross?
Thank you, Your Honor. Good afternoon. In terms of your experience, I understand prior to becoming the assistant dean, you were a long-term substitute over in Lake Orion.
That is correct, yes.
And you have a degree in what?
I have a master's degree in
Check
education
the banner.
and development
Banner below.
and a bachelor's degree in sociology.
And did you ever have any training specific to disciplining students or discipline issues?
Yes, on-the-job training.
When you say you had on-the-job training, where was that?
So my job previous to being a long-term substitute teacher, I was the dean of students for an alternative program.
Does anyone in your school have training
Discipline.
in mental health?
And then I spent 3 years
Anyone?
for Brandon School District as an intervention specialist. And so I specifically dealt with student behavior.
In the trainings you did, were you taught signs of things to look for in students that would have discipline issues?
Yes, I was.
I believe you mentioned that one of those signs that you would know to look for in terms of thinking about what, if you need to search their backpack, would be whether they seem nervous when you're holding their materials, correct?
Yes.
Now, in this case, there was a time where you walked down to the classroom and retrieved Mrs. Crumbley's son's backpack.
Yes.
And you carried that backpack to the office where you were meeting with Mr. Hopkins and Mr. Crumbley's son, Mrs. Crumbley's son.
Yes.
When you carried that backpack back to Mrs. Crumbley's son, he did not appear to be nervous at all that you were holding his backpack.
He didn't appear to even care that I was holding his backpack.
And so based on him not caring or showing signs of nervousness, you had no concern there was anything in that bag.
I had no reason.
Did you ask him?
to search his belongings, no.
Did you ask?
You did make the observation that that bag felt unusually heavy.
That is not correct.
Did you ever make the observation about how heavy the bag seemed?
I made a joke to Miss Morgan at how easily she picked it up and then handed it to me and my arm dropped. And so it was more of a joke of how strong she was compared to handing it off to me.
I see.
So that's a
So
common.
you had
problem.
training through your employment with the Brandon School District.
You gotta
Correct,
follow
yes.
up.
You
Why
had
didn't you ask
training
about the
when
gun?
you were working on your
I'm just,
undergraduate
is any
degree.
weapons in there?
Correct, yes.
You obviously have your advanced master's degree.
That is correct.
You have the experience from working
She's
in
gonna hang
the
her
school
picture.
across state.
That is correct.
And you probably have attended other seminars and things to keep up to date on any recent developments in this area.
Yes.
How many additional hours would you say you've spent in those additional trainings?
I'm not sure.
Are you required to do a certain number per year?
No, I'm not.
But you do those trainings?
Yes.
Have you done more than one training?
Yes.
More than 5?
No.
And you
So
couldn't-
your main job or responsibility at Oxford High School was to be in charge of discipline issues with the students.
That was one of them, yes.
And when you were looking at any situation involving Mrs. Crumbley's son, there was nothing that you determined required a disciplinary action.
There was nothing that had required discipline in that situation, no.
So we talked yesterday about how Mrs. Crumbley's son was caught
didn't talk
looking
yesterday.
up bullets during class time.
Yes.
There was no discipline needed after he's looking up bullets in a classroom.
That doesn't reach to the level where there would be a consequence.
And with respect to that issue, there was a phone call and a voicemail left for Mrs. Crumbley.
That is correct.
You were present when Ms. Fine left the message.
I was not present when she left the message.
Mr. Hopkins was present when the message was left.
I can't speak to that.
Who cares? Who cares who's?
As far as you knew, Mrs. Crumbley was not asked to come to the school regarding the bullets.
As far as I know, she wasn't. No.
And Mrs. Crumbley was not asked to call back to the school, as far as you know,
She was asked to return the phone call if she had any questions about what had occurred.
but not asked to return the phone call no matter what.
No, we often just give parents phone calls when we meet with students regardless of the issue, just to keep them informed on what we talked about, without a request to return phone call.
Now,
This is
when
inept.
you were
This is so
speaking
bad.
with the prosecutor, you were shown exhibit number 158. I'm gonna pull that up on the screen.
Did you ask him if he had a weapon? Did you ask him if he had a gun? Did you talk to him about whether or not he was suicidal.
So
Did you
I got
ask the parents
158
to
up
take him
there.
home? Not were you in the room when a freaking
And this
message
is
was
an
left on
email
a
chain
phone?
that went between Miss Kubina and yourself. Is that correct? I'm sorry, I'll back up. I can see that this went between Miss Kubina and
There's
Shawn
no
Hopkins.
inadequate counsel.
Were you made aware of the contents within this email that's in Exhibit 158?
Yes,
And in Exhibit 158, Miss Kubina wrote, not only was he looking up the bullets, but that when she reviewed his previous work that he's completed, it leans towards the violent side, correct?
that's what it says, correct.
Did you go and ask Miss Kubina to provide you some of the work he completed that appeared violent?
I did not do that.
This does nothing to help your client. This does nothing to help them.
So it was not necessary for you to specifically speak with Miss Crumbley in any way
No,
about the
it wasn't.
bullets, drawing, or
That's what he's going to
research.
say. You know he's going to say that.
It was not necessary.
And it was not necessary for
That's
you to
correct.
look at
Paul
what
said
were
it was
described as violent side indications in his prior work.
It
Is
was
this
not
helping your
necessary
client?
because another staff member had already taken care of this issue, so I didn't need to get involved any further.
And you did not mention to Mrs. Crumbley at any point in time that a teacher had described prior work of her son to be on the violent side.
Can you rephrase the question?
Sure. Did you ever talk to Mrs. Crumbley that there was an indication from a teacher that her son
Yeah,
had
that could be a beneficial.
prior work that leaned on the violent side?
During the meeting that we had on the 30th.
What did you say?
You're saying you discussed.
We discussed that during the meeting we had on the 30th.
So why didn't you ask
But
him whether
at
he had
that
any
time,
weapons?
you didn't even have the violent leaning materials, correct?
That is correct.
And
I
you
don't
didn't
know.
show her any of the examples that you would say
He seems
would
very
be
afraid.
violent leaning materials.
Didn't have those to show her, no.
And as far as you were aware, well, I'll ask if you were you aware if anyone ever discussed violent leaning drawings or violent leaning work in the past with Mrs. Crumbley?
Because this is
Are
an
you
important
aware?
thing. This is a
I'm
beneficial
not
thing.
aware of that, nor there was any documentation.
You never called the violence
prior
to
this.
Jennifer's
It is
attention.
correct.
Now, on November 30th, we know that you were told inappropriate things were being drawn on the math paper. Or I'm sorry, you testified that inappropriate things were drawn on the math paper, correct?
That is correct.
And when you're talking about the math paper, you're speaking about what we see in Exhibit 74 that has drawings and writings
This is the math.
by Mrs. Crumbley's son on the paper.
That is correct.
You're aware that Mrs. Crumbley's son was drawing these things and writing these words during class time when he was supposed to be working on this review, correct?
Yep.
And that did not create a discipline issue
Well,
to you?
when he's seen for mental health, that supersedes any type of minor violation that this would
Well, there you go.
potentially rise
Bring
to.
it up
But
also.
this doesn't violate any of the code of our conduct. So there wouldn't be discipline. And as I mentioned, because of the fact that he was being seen by his counselor for mental health, that's what takes precedence in the situation.
That was explained to Mrs. Crumbley. This is not a discipline issue. Your son is not in trouble for this drawing, correct?
Yes,
And you explained to Mrs. Crumbley, we're concerned about mental health, not disciplining him for this drawing.
yes.
And during that meeting,
The
that
mental health
was,
was to
it
himself,
was a
not to others.
conclusion by you that this was not, you and Mr. Hopkins together, that this was not a discipline issue, but a mental health issue.
So I was there for discipline and
You
behavior,
have
so
to
that
count.
question was posed to me to make that call as part of my.
He's a danger
job.
to
And what
himself,
was the call
not
you
to
The
made?
others.
call that I made was that there's no discipline warranted, that I'm more concerned that he gets the help that he needs.
Because he's a danger to himself,
During that meeting,
not others.
were you
You have
aware
to hit that.
that another teacher had reported Mrs. Crumbley's son was looking at a violent video in class?
Yes, that is why Shawn thought that I had come to his office that morning. So he had shared that he had gotten an email from the other teacher.
Did you ask to see the violent video that Mrs. Crumbley's son had been watching while he was in class?
I
did
agree
not
with
ask to
this.
see
It's
that.
very
It
frustrating.
wasn't necessary.
You found it to not be necessary to take a look at the video that he had been watching?
No.
You didn't even ask Mrs. Crumbley's son, hey, can I see it? Take a look at that video.
Well, since it was described as not like a live event, and due to the fact that most teenagers are watching violent movies, video games, pre-recorded on YouTube, it doesn't rise to the occasion where you would.
Oh, so it's not foreseeable.
And it also
This is
didn't
where you have to
rise
hit
to the
in.
occasion that you felt he should be disciplined for watching a video during class time.
That also wouldn't rise to the occasion of a violation of our code of conduct. That would be more of a teacher-managed behavior. You would never be suspended for that, or that wouldn't rise to that occasion.
I went to school in a different day and age where
Oh
you
my
had to do school during
Oh my
school.
God.
So it sounds to me like during school, Oxford High School allows more freedom than what I experienced. So it was okay that he was looking at the bullets. That's not a discipline issue.
It's not that it was okay, it just doesn't rise to the occasion that you receive a suspension as a consequence. We have to rely on restorative practices instead of going right to suspension, as you mentioned that you might have experienced when you were in school. And we have to consider how the student's behavior interferes with the day and discuss that with them and talk about how we can move forward. And that has to be considered for all minor violations before you would ever consider a suspension. And that's something that we have to do by law.
So, and when you're considering all of these things, you're ultimately concluding these are minor violations if they're violations at all, correct?
That is correct.
The looking at bullets in the classroom,
Yes.
the looking at a video, violent video on his phone,
Yes.
the drawings on this
Good.
math
Bring home the
paper,
totality.
Yes.
Good.
the drawings on the amended math paper where Mrs. Crumbley's son made other marks on the page.
The other marks
So
on the
the
page.
drawings at the moment were not.
These are the
as
other marks on the
important as
page.
Stand out as the statements were. So when you have the explanation of the desire to design video games, and that's how he was practicing the drawing, and you have the parents confirm that information, it lowers the level of concern immensely.
So you took into account the context
Fuckers.
of what you were understanding, and that was part of what helped you conclude this was not a disciplinary issue.
That is correct.
You're drowning, lady. You're drowning.
Now,
you have to
In
count
terms of any disciplinary
that
issues.
there was no
with
foreseeability
Mrs.
of a threat
Crumbley's
to
son
others.
Prior, would those show up on Power Schools?
They would, yes.
It's fair to say that when you look at Power Schools, you don't see any history of disciplinary action against Mrs. Crumbley's son.
There was no history of discipline for Mrs. Crumbley's son.
All of his grades are available to be seen. Mrs. Crumbley's son, while he may not have had the best grades, had overall passing grades. Is that fair to say?
Pretty average for a student at the time, yes.
And when you're on Power Schools, you can also see attendance records and be able to tell if the student was in school often or missed school often, correct?
Yes.
And it appears from Power Schools that Mrs. Crumbley's son had very regular, very good attendance.
He did have regular appointments, yes.
So when you are looking at Mrs. Crumbley's son, it's fair to say he comes to you with no history that would cause you to be on higher alert.
That is correct.
And when I asked about prior incidents of discipline or things along those lines,
Sort of
you did not
dancing
see
around the right
anything
area.
from the 2020 to 2021 school year documented regarding discipline.
No, we would be able to see anything that would be in the history of attending Oxford schools, and there wasn't anything.
So she's dancing around the right areas, where it's like he's not a threat, he's not a discipline problem, it's not foreseeable.
When you heard
You should just say he's not foreseeable. Get him to
the
say
phone
that.
call to Mrs. Crumbley where she was asked, or it was suggested that a parent come to the school, her immediate reaction, you wanted to see her immediate reaction to seeing the paper from math class, correct?
Can you rephrase that question, please?
Sure, and I apologize. You testified that you wanted her immediate reaction when she saw the math paper you were dealing with, correct?
I wasn't looking for her immediate reaction. It was more, we're going to send you this that he just drew so you have it in front of you.
But you did end up getting her immediate reaction because
Yes.
she was on the phone at the time,
That, yes,
on speakerphone.
yes,
And you testified that her first reaction was to ask her son, what were you thinking? Why did you do this?
yes,
When you call parents and say, I need a parent to come up here for a meeting, oftentimes one parent or the other comes to the school.
that's not necessarily true.
Well, there are times where both parents come to the school together.
Yes,
There are also times where one parent or the other parent come to the school.
fair statement.
And when you're asking for a parent to come to the school,
Drowning.
you are not specifically saying it has to be mom, or it has to be dad, or it has to be both, correct?
It just has to be whoever's legally allowed to, yes.
And in this case, legally allowed to would be both mom and dad, Mr. Crumbley and Mrs. Crumbley.
Yes,
So according to your request for a parent to come to the school, it's perfectly okay if it would be Mrs. Crumbley who comes, Mr. Crumbley who comes,
This is
or
a good
both
point. She's
parents.
trying to make a
Yes.
point that they both
In
came
this
because they both
circumstance,
cared.
both parents came to the school.
correct.
And they both attended the meeting that lasted approximately 10 minutes, as you said.
Her point is, don't say she didn't care. She didn't have to come. She could have just sent the husband.
Now, this was the
that's a
first
good
time
point to make.
that you ever
It's very
had
secondary.
the Crumbley parents come to the school regarding their son, correct?
That I was involved in? Yes,
And that you're aware of.
that, yes,
You would have seen on Power Schools if Mrs. Crumbley had been up at the school many times the year before, or the year before that, or the year before that, correct?
it depending on the type of meeting, potentially. If they're meeting with the teacher, it probably would be listed in Power School.
So discipline meetings would have been on there, and you didn't see
Correct.
any history of Mrs. Crumbley coming to the school for discipline.
That's correct.
So she was a person that when she arrived, you did not know from prior occasions with, you had not had many communications or any communications with Mrs. Crumbley where you would know who she is or how she is.
That's correct.
During the meeting, Mr. Hopkins supplied Mr. Crumbley and Mrs. Crumbley with the sheet of resources, including many therapists listed.
That's correct.
And on that sheet, there's also Common Ground is listed in some other mental health facilities.
I can't speak to what's included on this.
During that meeting, you indicated to Mr. and Mrs. Crumbley that you wanted them to get counseling for their son.
I did not indicate that, no.
Mr. Hopkins did,
Yes,
but you agreed with that.
I do.
And when that happened, there was not any specific direction, you need to go to Common Ground.
No, the direction was as soon as possible, that day if possible.
as soon as possible.
just
that
common
day
ground
is possible,
specifically?
if possible. But it's okay if it was going to end up being on a different day.
Or hours later, many hours later,
I
not
can't
right
speak to
now.
that. I can speak to the statement that was made that Mr. Hopkins would be following.
Did
up
you
within
say
48
taken to
hours
common ground
ensure
now?
That they had made arrangements for that, which means they had 48 hours to secure.
Okay, 48 hours, not
And
an
by
hour and a half.
secure some type of counseling, you mean scheduling an appointment, making steps to get mental health counseling, correct?
Correct, after they said they were not going to be taking their son out that day.
Now, during the meeting, well, as the dean
You didn't
of
view him as an imminent threat.
students,
It's not
you're aware
foreseeable.
that there
Hit
are
him.
some circumstances where children or students at Oxford High are not permitted to stay at school, correct?
There are situations where students wouldn't be permitted to stay at school, yes.
If a student comes to school and is positive for COVID, you would not allow the student to stay there.
That's a fair statement, yes.
No one cares
If
about.
a student has a temperature and is sick, you would not allow the student to stay there.
If they were a threat to others.
And if the parent said, no, I'm not going to get them, they're fine, the school would still say, no, you have to take them home, correct?
We've said that in the past and it still hasn't happened.
But
It
you didn't
hasn't
even
happened
try
where
it.
a parent hasn't taken the child home. Is that what you're saying?
What I'm saying is, in that specific case where students have had a fever and parents refuse to come pick them up,
Did
they
you-
remain at school.
But you had the authority to at least
I've
say
been
it to
in
them.
situations where parents were refusing to come pick them up.
So you end up letting so there are times then where you want the child picked up, but they don't get picked up, and the school doesn't do anything about it to force the parents to come.
There's nothing that we have the power to do to force parents to do anything.
If you said, if there was a discipline issue, if you had looked at this as a discipline issue
A threat
and
to
told
others.
the parent, your child cannot stay here because of this discipline issue, you do have the authority to say you must take your child home, correct?
I have the
If you
authority
knew he was
to
going to shoot up the
recommend
school,
that. However,
would
I
you have
can't
sent him
force
home?
them to do that.
If you thought there was a
doesn't
chance he would
reach
shoot up the
a
school,
level
would you
where
have sent
there's
him home?
illegal behavior, I wouldn't be able to do anything further than
Hit him on the
recommend picking
foreseeability
up the
directly,
child cannot
not about
be in school.
COVID.
But I can't force them to do anything.
Okay, but in this circumstance, in this particular circumstance, there was discussion where ultimately it was okay in your mind for Mrs. Crumbley's son to remain in school.
From a discipline standpoint, yes. There wasn't a reason to suspend.
What
him.
about a threat
There was
to
no
others?
Violation of our code of conduct that reaches the level of suspension.
And if you thought Mrs. Crumbley or Mr. Crumbley were neglecting their son medically, you are mandated by law to report that, correct?
Yep, absolutely.
So it's fair to say that even looking at it from a counseling mental health perspective, you did not find that Mr. Crumbley and Mrs. Crumbley were meeting a level of being so neglectful that you needed to call to report that, correct?
I'm going to need mental
No,
health
because
from
I wasn't
watching this.
made aware of all the additional information that they were withholding.
It's important for you to have all the information you can, correct?
True. I
You
can't
would-
force people to share information with me.
You would also
You
agree
could at least ask
that
them.
the school had information they didn't share with Mrs. Crumbley.
We had shared all the information that we had with her at the time of the parent meeting.
You would agree with me that there has
So
been
not good at
claims
this.
of prior disciplinary issues that from your documentation in Power Schools is not even included, correct?
I wouldn't agree with that. No.
I'm sorry, did I misunderstand? Is those prior discipline issues are on there?
There weren't any prior discipline issues.
Right, so there's no prior discipline issues listed on there. You testified you never spoke with Mrs. Crumbley about discipline issues.
Yeah, that's correct.
So you don't have any evidence that Mrs. Crumbley received all the information that the school would have or could have known.
Can you rephrase that question?
You don't know that Mrs. Crumbley had received information about every specific situation with her son, correct?
The specific information discussed in the emails that was shared with Mrs. Crumbley.
Right, so on that day, you're discussing with her limited information compared to the whole picture.
It was the information that we had at the time. All the information we had was shared with her.
Are you saying that when they came in, you shared the emails with her too?
So the emails that we received from the teachers, correct?
Oh, okay. Okay.
At no point in time did you believe that Mrs. Crumbley's son posed a threat to the school.
He did not pose a threat to the school.
If he posed a threat to the school, that's something that you have been trained in to identify, correct?
Correct. We had previous threats that year that I handled completely different based on the fact that
They were
it was a
threats.
perceived threat, correct?
And when something is a threat, how is it that you handle it differently? Is the student allowed to stay in school?
No.
So you are the decision
finally, we're
maker
getting
about
there.
whether or not there is a threat overall.
I wouldn't say that I'm the decision maker, but I have the power to
Finally.
heighten it to the level where we can get other people involved that can make a more informed decision.
And you're the one that has the training on that topic.
I'm one of them, yes.
Finally.
And in this case, your conclusion was that the shooter's son was not a threat.
There was no threat present at the time.
Thank you. Thank you. My God.
You also took into account that what Mrs. Crumbley's son said made it sound like there were issues of sadness versus anything threatening, correct?
Correct, which is very typical of most teenagers.
Very typical.
Very typical of most teenagers, especially at that time with COVID, to feel sad. It was not unusual to hear that throughout the day.
Now, some of the statements on the math paper, you saw the statements that say things like, I love my life so much, and OHS, which I assume stands for Oxford High School, rocks, correct?
Yes.
Those kind of statements also, would you agree those are mixed signal kind of statements?
No, I would say it looks like you have a teenager who is trying to not get in trouble.
Unmasked,
The team of students is involved most of the time. When I'm involved in student meetings, the kids always think they're in trouble, which is not necessarily always the case. So I looked at that as he was trying to get himself out of being in trouble. Thinking he was going to be in trouble from this meeting we were holding.
And that was something that's not unusual for you to see.
That's not unusual, no.
That doesn't mean there's a threat to you.
That doesn't mean there's a threat, no.
Yep.
In terms of Oxford and the
You
area
think that's reasonably
community,
suspicious, right?
You're familiar with the fact that students at the school, there are many who are interested in hunting, guns, target practice, that kind of thing, correct?
Yes, during hunting season, it's kind of like a reminder that sort of gets put out for students that go hunting in the mornings before the late start Wednesdays to remember to not come to school in their gear and or have weapons in their vehicles from that morning. And like we've also had students that pose with guns for their homecoming pictures as well. So it's very common in the Oxford community.
Okay, so it's so common that there are students, they pose for homecoming
There
pictures.
have been students that'll pose with guns for homecoming photos.
When you're talking about homecoming photos, you're talking about like the dance.
They're dressed up at home and taking photos, correct?
So they're dressed up in their, little party dresses, and they're holding guns in the photographs before they go to the dance?
Yes.
And you're saying that there are students who go hunting in the mornings before even coming to school?
Yes, so at the time, we had late start Wednesdays, so school didn't start till 10:20-ish. So when hunting season would start, they potentially could be out hunting with their parents in the morning.
So in addition to what you did know in this case, seeing a gun or talks of a gun, that was not something that caused alarm to make you think there was some kind of threat.
No, nor
Guns-
was I aware that he even had a gun.
guns at that school
you
are
ask them if
very,
you
are
had a
very common. But it sounds like it's a common topic if they're in pictures of homecoming dresses and things like that.
I would say across many schools,
This is good.
It wouldn't be uncommon to see guns drawn on assignments or papers. Oftentimes, there are certain books or part of the curriculum, and students end up drawing guns to represent stuff in the stories.
Now, my understanding is that you guys recommended immediate care. I'm sorry, I'm going to strike that. I was going into a question I've already asked you.
And my new objection sign.
You did not think it was strange that the parents were not taking their son out of school, specifically with Mrs. Crumbley's son on November 30th, correct?
I did think it was strange that they didn't take their son.
You've testified before in civil cases regarding what happened at Oxford High School, correct?
I have, yes.
And specifically on September 14th of 2022, you testified in a deposition, correct?
That sounds about right, yes.
And when you testify in a deposition, it's not like a courtroom like this, right?
No, it's not.
But you still have to swear to tell the truth and take an oath before you testify.
Correct.
On that day, you were specifically asked, so them not taking Ethan home that day, you did not find that to be strange and out of the ordinary. Your answer was no. There would have been no reason for him to go home.
That was in regards to student discipline. So the context, I believe, is important there.
That's in regard to student discipline.
Correct.
But that was the question you were asked that day and the answer you gave.
In regards to being disciplined or suspended, correct?
And in terms of a mental health consideration, it was not something that arose to the level, whereas a mandatory reporter, you would have to report the Crumbleys for being neglectful. We've already established that, correct?
Yes.
In the meeting you had, there was no indication, and there is nothing in Mrs. Crumbley's son's record to show there had ever been a previous concern about the need for mental health to Mr. Crumbley.
Judge, I think we've already answered this question.
No, I asked about prior discipline, but I didn't ask about prior notations mental health was necessary.
Okay, all right, go ahead.
From a school standpoint, we did not have any record of mental health.
Now, when you testified previously, you testified that Mrs. Crumbley seemed receptive and willing to get mental health treatment for her son.
That was my understanding at the end of that meeting, yes.
Although maybe not that day, it was your understanding she was on board and was going to make an appointment or do something within 48 hours.
That was my understanding and hope.
When you were in the meeting and the struggle was discussed, ongoing struggle between the Crumbleys and their son, would you agree with me that the parents were making statements about they were concerned with their son's schoolwork and grades?
They just confirmed that they had the argument. They didn't provide
Thank
any
you.
context or details about anything other than what he had shared with us before they died.
Were you aware there was a specific concern related to Mrs. Crumbley's son having missing assignments specifically?
The only information that she provided was that he struggled with virtual learning, which was confirming what he had also shared with us. But there was nothing specific that I remember her sharing.
And you would agree with me that when you meet with parents, parents all react differently to their child being brought down to the office.
That depends on the situation.
So depending on the situation, parents may have a variety of reactions.
It depends on it depends on what the meeting is, yeah. What the meeting is about, why we're meeting with the parents and the child.
Obviously, when parents come to the school, they're showing you a level of concern to make sure to handle whatever it is going on, correct?
Somewhat, yeah.
And you're aware that when the parents are coming to a meeting, they are going to be getting information and from you and from other professionals at the school.
As well as providing information that they have, because they're the experts on the child. So part of the meeting is to share what we have, but also to listen to confirmation or additional details about stuff that they might be seeing outside of school, at home. And that information was not provided.
There was no information provided to you that the Crumbleys had concerns over mental health issues. Fair to say?
That's fair to say.
I have nothing further.
Thank you. Mr. Ejak, let's talk about the whole picture. Okay, so you testified that as dean of students, you need reasonable suspicion to search a student's personal items such as a backpack.
Yeah, that's correct.
Okay. And on November the 30th, 2021, it was your perception with the information you were given that you didn't possess reasonable suspicion.
That's correct.
And you also had a perception with the information you were given on November 30th, 2021, that the defendant's son wasn't a threat to anyone else.
That's correct.
Okay. So you had told us that Jennifer Crumbley just confirmed some items that her son had told you prior to her arrival.
Yes.
Did she ever tell you that in March of 2021 and April of 2021 that her son was hallucinating, or at least expressing that he was hallucinating?
No, she did not.
Okay. Did she ever tell you in April of 2021 that she had told her friend that she thought her son was depressed?
No, she did not.
Did she ever tell you that as early as June of 2021,
This is a wise
she had
move by
indicated that he had obtained his own
prosecution
firearm?
No.
to show all the
Okay, now,
knowledge
one
that
of the
parents
reasons
had
you
that the
told
school
us
did
about
not have.
reasonable suspicion, you said if you believe the student has a weapon or access to a weapon. Is that important to you as dean of students?
Absolutely, yes.
Okay.
Why didn't you
If you had
ask?
information
You know
that
a lot
the
of kids have
student had
weapons.
access to a firearm in conjunction with that
That's so
photograph
stupid.
that you saw in Exhibit 74.
And that's where she
What
failed
would that
again,
indicate
defense
to you?
counsel.
That would indicate that I need to heighten it to the next level.
Why didn't you ask? That's what the defense counsel never asked him.
Okay. And did Jennifer Crumbley ever tell you that she had given her son a 6-hour 9mm handgun just 4 days before this drawing was created?
She did not know.
Would that have been important to you?
Absolutely, yes.
Would that have helped complete the full picture?
It would have, and it would have completely changed the process that we followed.
Why didn't you ask?
Now you talk about decision makers. Between parent and child, who's the decision maker?
You know, a lot of kids have guns.
And decision makers as to if a student stays in school or not. Who's a decision maker? Parent or administrator?
I would object because in this case, there has been discussion and testimony that the student was a part of the decision and so were the parents. And so I would say that the opinion on this question is irrelevant.
Part of the decision.
I take it the objection is on MRE 401 relevance. In response, counsel on her cross-examination specifically asked him about the decision maker, he being the decision maker. And I believe this.
Yeah, I'm gonna allow it.
Thank you.
Mhm.
Okay, so between you, Mr. Hopkins, Jennifer, and James Crumbley, who were the decision makers?
So I would say the main decision maker would have been the parents.
The parent. And
You think
you've
she'll
never
do better on a second
seen
bite at the apple?
defendant's son.
Your Honor, I would ask that the prosecution stop asking leading questions.
Sustain.
That's fine. Okay.
Just say
If
objection
you were given
leading.
the full picture, what would have taken for you to heighten that to reasonable suspicion to search a backpack?
Any type of
Act like you've been there
indicator
before.
that, the student was going to be a threat to anybody, including himself. That would have heightened it to the next level.
And when you have a
indicator that there was access to a firearm, or that he had made comments about wanting to hurt anybody, any statements written on there with names, or I'm going to do this, I'm doing it, like those would have all been things that would have changed the process that we followed.
And when you have a meeting with a parent and a student, do you rely upon the parent to provide information?
Absolutely. As an expert of their child, heavily rely on the parent for information.
Thank you.
Your Honor, may I ask one
Did you
question
ask?
to redirect? You also, so you're from a community where
Recrossed,
guns
not
are
redirect.
popular, and you testified about that. You also didn't ask if the
Thank you.
Crumbleys had a gun, correct?
Thank you.
I did not ask that.
You're aware many of the families in Oxford have guns, but
Thank
you did not ask them specifically if they had one, and they didn't tell you.
I didn't ask that question.
Thank you. Finally. God.
No, Judge, thank you.
You can step down in your seat.
Her whole crossed. I was just thinking.
He's in the hallway out there.
Wait, sir.
Good morning. Good morning.
Morning.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you?
Yes.
All right, you may be seated, and would you state your name for the record and spell your first and last name?
Andrew Smith, Andrew Smith, SMI.
Go ahead, Pastor.
Good morning, Mr. Smith.
Good morning.
Can you tell the jury what your profession is?
I work for a real estate company. I'm the chief operating officer.
But you're also a lawyer.
And also I'm a lawyer. Yeah.
Okay. All right.
It's probably her boss.
So you're not technically practicing law, is that fair to say? Or
Not normally, from time to time I will, but that's not my primary responsibility.
okay, what are your primary responsibilities?
My title, I'm responsible for all the operations of a portfolio of real estate holdings, commercial, multifamily, industrial, throughout the country.
And about how many employees in the company?
Approximately 700.
Okay, so you're the COO of a real estate management company that has 700 employees. Did I get that right?
That's correct.
Okay. Do you know Jennifer Crumbley?
I do.
How do you know her?
She worked for our company. She was the marketing director at my company.
Do you know what the time frame that was?
I believe she had been a marketing director for approximately a year, a little longer. Before that, she was on the marketing team in a different capacity. I'm not really sure when she hired in, but it was approximately 5 years, give or take, I think.
Okay. Do you see her in the courtroom today?
I do.
Can you tell the judge something she's wearing?
Tan brown, luxury sport coat, and glasses.
May the record reflect he's properly identified the defendant for the record.
This guy looks like the Marlboro Man.
So, did you supervise Jennifer Crumbley?
I was her direct supervisor when she was the marketing director, yes.
So how long was that?
I believe that was a year to year and a half.
What were her responsibilities
I
as
agree.
the marketing director?
She was responsible for handling the marketing of our portfolio of properties, dealing with outside vendors, social media, dealing with reviews, online reviews, helping with leasing training.
Also should have hit. You didn't ask him. You didn't ask the parents. You didn't ask either of them.
Okay, and so does your company have social media accounts?
Yes.
What accounts do they have? In general, you don't have to
In
say.
general, I know they have Facebook accounts for properties, and they have, I believe, Instagram as well.
Okay. Can you tell the jury what Jennifer's work week is? How many hours was she required to work, and what were the times that her beginning and end time?
I can approximate. She was a director, so I know she was responsible to work a 40-hour work week. The start and finish time fluctuated depending on schedules, whether it was 8 to 4, 9 to 5 type scenario.
Did she have a set schedule, or did it change day to day?
It was somewhat set with some flexibility depending on what was needed. I believe she came a little bit early, left a little bit early, if I recall correctly.
Okay. Was she ever allowed to work from home?
Yes, there was occasions where she would work remote.
And so you're saying she had done that before?
Yes.
Okay.
What's OJ?
Talk to me about the company's
I don't know what that is.
culture in terms of families.
I think we're very family friendly, family first type atmosphere.
So do you have employees that have issues with kids or family or personal things?
The idea is show she could have manipulated her
and
schedule.
What is
but
the
chose
the
not
company
to.
policy on that?
That's what the objective
I
is in
think
this
we're
line
very
of questioning.
big on family first culture. You can need time away we have a PTO policy, paid time off policy.
The point
cover
being, she could
any of
have
your
stayed home and
needs,
taken
but we also
care
are
of
very
Ethan,
friendly when it comes to
but chose not to.
needing time for addressing what may be a child issue or child care, whatever it may be. Routinely, people will bring kids into work because of post-COVID needs for daycare and school closings and snow days, things like that.
Yeah, seriously, that's what she is. That's good. It's a good
What
call.
happened when the pandemic was in full force? Were employees still coming in every day, or were they working remotely, or both?
There was a little bit of both, depending on the job and the ability to do so.
Okay. Does the company provide health insurance?
We offer health insurance, yes.
And do you know if Jennifer had health insurance?
I do not know.
Okay. Do you know whether or not anyone else in her family was insured?
I have no idea. On our company policy?
The idea
I'd have to look at
being
those records. I don't
that
know.
Ethan would have been
so if I handed
covered
you
for
the
mental
records,
health
would that
issues through
refresh
their
your
insurance.
I'm not in charge of HR, but it would at least, I would assume, indicate whether or not she was on our policy.
Okay, thank you. You're the CEO, correct?
Correct.
Who does the human resources person report to?
A few people would be included.
Okay, and do you, does the company regularly keep benefits documents in the normal course of business for each employee?
Absolutely.
Okay, may I approach your honor?
Sure.
Mr. Smith, I'm handing you a portion of the personnel file for Jennifer Crumbley that the defense has been provided. What is that?
This appears to be a 2021 new hire open enrollment form for what I believe to be healthcare options, medical healthcare options that year.
Okay, and I'm sorry, can I approach? Is this what you're looking at? This is contained in there. I just want to make.
Yeah, this has got this is a different document, but it's similar. Okay.
All right, and what is that document? That's also part of her personnel file, but what is that?
Okay, the document you handed me appears to be a Guardian life insurance open enrollment form for 2021 for Jennifer Crumbley.
Okay, and the previous document you just had, what does that indicate? Who is enrolled in the health benefits?
It appears to be for Jennifer Crumbley, and there were multiple options. It appears she checked, or someone checked the box. She did, I believe, for single medical low plan.
And how much was that per month, if you know?
Well, it listed as $102.55 bi-weekly, so I guess it'd be $204 or $5 approximately a month.
And do you know approximately what the cost would have been to add somebody in her family?
So if on this plan, if I follow it from single to employee plus one, it would have been $404. Family, $533.81.
Is that once a month or 5?
These are all bi-weekly.
Okay.
Bi-weekly. That's not too cheap.
May I approach it?
You're not marking that.
No. I want to talk to you about November 30th, 2021. Do you remember that day?
I do.
Okay. As a matter of your daily routine, what were your hours?
It depends on my day, where I'm going, what's going on that day, but it's typical standard 40-hour work week. Some days can be longer, some days can be shorter.
You're also a parent, so did you come in early or did you come in late? What were you?
I remember that day specifically. I forget I was coming from that morning, but I remember that I was driving when I got a text from her that morning. I think it was around 10 a.m.
Okay. I'm going to show you an exhibit that's, I think it's been previously marked, that is from Jennifer's phone. How did you communicate with Jennifer?
In person, email.
Text message or Facebook Messenger? I'm sorry.
Oh, use text message would be primary. Yeah, text message.
Okay. This has been marked 152. I don't know if the jurors' eyes are. Oh, thank you so much. This monitor's not on.
Your Honor, I believe it's not only been marked, but it's admitted. I
It's
just want
admitted.
just check.
Yeah.
Okay.
Yeah, she's noticing that the TV isn't on. So I don't know how to turn it on. Magic. There we go. It's on.
Okay, thank you. Could the jury let me know if they can't see? I have a little trouble with seeing that. But can you see on the monitor?
Yes.
These are communications that begin that morning or that day, just from Jennifer Crumbley's phone. Looking through this exhibit, is that representative of your text messages that day?
I recognize the first two texts, and I believe I recognize all these texts directly.
Okay, is this the entire communication you had that day?
No.
So are you saying something's missing?
Yes.
All right. I'm going to now show you screenshots that we received from your phone and your text messages between Jennifer Crumbley that same day.
I can't believe she's showing this
Okay.
picture to everyone.
Is your testimony that these
She's
accurately
crazy.
depict the entire
She's
text
such a-
conversation of
she's-
that day?
Could you scroll down?
Sure.
Why would you show this to like your boss? She showed this to the stable woman. Like what? It's like what is wrong with? She's such a God idiot.
This looks accurate, yes.
Okay, so the message, the exhibit I just showed you
Stupid
had
human being.
4 messages, around 4 or 5. This is actually several messages. Is this your full conversation?
This would be the full conversation, yes, I texted that.
Okay. And when did you never deleted any text messages that, okay. So this is exactly what it was that you turned over to law enforcement.
Yes.
All right, thank you. The first text, if you can see this exhibit, if you go to the top, Mr. Smith, what's the time on the first text you received from Jennifer Crumbley?
This is Tuesday, 10:05 a.m.
And you said earlier, did you say you were driving to work or you were at work?
I forget, I was driving, where I was going, I don't recall. Probably to work or coming from property, but I was
All right.
driving, yes.
Assuming you weren't reading your text messages while driving, this is when you received the text. Can you read her text to you?
I have to go to my kid's school. Counselor just called, and this is what I'm dealing with. I'll be back by 11:30, 12 at the latest.
Okay, so that text came in at 10:05, and she is telling you exactly when she'll be back.
That's what it says, yeah.
Okay, so then she attaches this, a picture. Do you know what that is?
I know now what it is.
Did you look at it at the time you received it?
No, I did look at it. It was later that day I looked at it, but not at the time. I was driving at the time. I just saw the text on my phone pop up. And I
Okay.
just saw him.
Was it required that Jennifer let you know if she was leaving and where she was going, or was this unusual?
No, I mean, we want people to let us know if they're leaving, coming, going. She was good about that. She let me know if she was coming and going.
Sorry, is there something going on?
No, but it's, okay, thank you. Can you, the next, I believe there's some issue with a camera in the back, but I don't know. Can I proceed, Your Honor?
Your Honor, I'm sorry, it's very distracting, so I'm just asking if
Wait, what do
there's
you mean?
something happening.
Yeah.
Can we-
I'm sorry, what did you say?
What is distracting?
Oh, it's hard to hear the witness, yeah. Everything has to be quiet, okay? Yeah. Yes, thank you.
May I proceed?
Yes.
The next message, well, before we get to the next message, tell me when was the first time you actually saw Jennifer Crumbley that day?
I recall, I don't remember the exact timeline. It's been 2 years, but I recall seeing her at the office around noon that day.
And where did you see her?
It was in the copy room. It was like an open copy room, storage type stationary area.
And did she say anything to you?
I recall walking up to her asking how was she doing? Was she doing okay? And I recalled her mentioning that she had to get her child counseling. She seemed down. I think she had mentioned a few things. I recall her mentioning that his dog had passed away and a grandparent or grandparents had passed away. She may have said more. I remember she seemed down. I think she said she felt like she was failing him, and she had to get in counseling.
When she said, I feel like I'm failing him, who was she talking about?
I believe her son.
That seems like she
What
cares.
was your response?
That's good. That's
I
not
remember
bad.
saying, if he needs counseling, glad you're getting him counseling. Get him the help he needs. We're glad to hear you're getting him that help.
Okay, did you and Jennifer have a friendship outside of work?
No,
Did you ever socialize together outside of any work centered event?
No.
You said you didn't Facebook message her, your conversations were just text or calling or email?
there may have been a Facebook message where she would send me photos from a property because of the size or scope I remember, but that'd be about it. But our communication will be in person, email, phone, or text.
And before this occurred, what, if anything, did you know about
Yeah.
her son?
Exactly, Jonathan.
And
Very
she had
low.
a son in
Shockingly
school.
low.
When she mentioned small talk, I knew he was in school. I recall something about him being in a bowling and avid bowler, I recall correctly. And I remember that she mentioned some vacations they went on, some camping, some family trips. I recalled her discussing, he had a part-time job, I remember mentioning it sometime in the past. No, small stuff like that, nothing much more.
Okay, did she ever talk to you about taking him skiing?
I know she was big into skiing. I don't recall her mentioning her son skiing, I don't know.
How do you know she was big into skiing?
She talked about it quite a bit. I recall, I think she like volunteered or she was like a volunteer ski instructor or ski school type thing. I don't remember
Or ski
exactly.
patrol?
Ski patrol sounds more right now.
Do you know where that was?
Local, one of the local mountains, local hills.
Was her son with her that day?
At the office on the 30th?
Yes.
No,
Would that have been allowed?
sure.
What was her schedule that day in terms of what she was required to be doing?
I don't know what her schedule was that day. She's director, I give her some flexibility. I do know that we had a property visit scheduled that afternoon that she was invited to.
Was that a required meeting?
No, not at all.
Did you know at that time the school asked Mrs. Crumbley to get him counseling that day?
Objection.
Yeah,
Assumes
yeah.
facts, not
No, she
evidence.
just told me
Oh
she
my
was-
God.
she
No,
had to get him
no.
counseling.
You have to object to that. That's crap. That's not what they told her. You suck, woman. God, why are you so not good at this
Project or
job?
assignment that Jennifer Crumbley was expected to do that day, an upcoming deadline that needed to be met that day?
I can't think of any deadline or anything bigger than this, but I'm sure she had a busy schedule as a director. I just don't recall anything specific now.
Okay. But I guess what I'm asking is, had she asked to leave that day, would that have been a problem for the company? Or you were her
It
supervisor?
would have been no problem at all.
Did she have any paid time off collected?
I don't know what bank she had for PTO, but it wouldn't have mattered to me.
When was the next time you had any contact with Jennifer Crumbley? After you saw her in the copy room?
We had a quick meeting with another colleague shortly thereafter, 20 minutes, 30 minutes thereafter.
Can you give me a time frame about?
I think I saw her in the copy room about noon. And so 20, 30 minutes thereafter, around 12:20, 12:30 that afternoon. And we talked about the property we were going to visit, kind of what our goals, why we were going there. And we had talked, I think, about some calls and things we had down the road a couple days later.
Okay, and when, after that was your next contact with her?
I recall, because I was in a Zoom hearing at the time, about 1 o'clock, I think it was.
Okay,
I heard some loud commotion outside my office, like yelling. And
how close is Jennifer Crumbley's office, was it to yours?
10, 12 feet away.
Okay, and you said you heard, I don't want to put words in your mouth, what did you hear?
No, I just remember yelling, like a commotion, loud noise, like yelling, screaming type noise coming from down the hall.
And what did you do next?
I stepped away from my hearing. I looked outside to see what the noise was, and I saw her like racing out of her office, racing down the hall.
Did you learn, or did she say where she was going or what she was upset about?
I recall her saying there was an active shooter at her child's school, and I remember seeing her go go.
And so obviously you didn't have a problem with her leaving.
Not at all, no.
When was the next time that you had any contact with her after she left around 1 o'clock?
I got the text on this thread, the one on, it says 123, the gun is gone, so are the bullets, was the next time I received any communication from her.
Okay, so she leaves around 1. The text comes in at 1:23. Let's talk about this for a second. Did you know something about a gun prior to this?
No,
Did you know that she had purchased a gun for her son?
no.
Okay, so when you got this text, what were you thinking?
I didn't know what to think. It alarmed me.
Okay,
She just run out and I got that text. I was really confused and alarmed.
all right, and what did you respond?
I responded by saying, I'm praying everything is okay.
And then the next text was from her. Can you read what she texted you?
There was a phone call that came in before that next text, maybe just for timeline. I remember that, but
Yes, I'm sorry, thank you. So she made a phone call that came in at what time? 1:25?
I don't remember the exact times. I can remember what happened.
Okay, so do you remember when you're saying the call came after I'm praying everything is okay?
I remember this because I was in a hearing, I was in a court hearing, covering hearing, and I stepped away and I got that because I was so alarmed by it that I walked down to my human resource director's office to let them know what had just transpired, to show her this text. And when I was in
And when you say this text, do you mean just the one, the gun's gone and so are the bullets?
Correct.
Okay, go ahead.
Correct. Then I recalled receiving a phone call from her. I was in my HR director's office at the time, and I put on speaker, and I remember there was a conversation.
And can you tell me what the conversation was about? What did Jennifer say?
I can't remember everything, but I remember vividly the sound of sirens in the background.
Was she in her car driving? Was she at home?
I believe she was in a car, I believe, driving. I remember her saying she was trying to get to her child's school.
Okay. So what did she say?
I remember her telling us she was trying to get to her child's school. I believe she said something about the gun was missing, or family gun was missing. It was me and our HR director were both said call the police, please call the police. I remember her saying that her husband had already called the police.
Okay. And were you aware that if her husband, first of all, had you ever met James Crumbley?
I never cursed him, no.
Okay. Were you aware that he in fact did call 911?
No, I mean, just what she told us.
Okay. Did she say he had already called or he was going to call?
I believe she said he had already called the police.
All right. What happened after that? Did you end the conversation? Did she end the conversation?
I don't remember much more. It was short. And they said, let us know if we can do to help, or let us know what we can do. Then I stayed with my HR director because we were trying to find out what was actually going on. And I got these next texts.
So you ended the call.
Yes.
You're still in the HR director's office, or were you in another room?
If I left, I would have left to go back to my office, which is about a minute away, to log off of Zoom.
Okay.
Or I can't remember exactly, but it would have been there or her office.
All right. And then the next text was from you or Jennifer?
It's from Jennifer to me.
Okay, and can you read that?
OMG, Andy, he's going to kill himself. He must be the shooter.
All right, now there's no timestamp on those specific messages, which normally would indicate they're coming in along the same string. Is that correct, or do you remember there was a significant period of time that lapsed?
I don't remember the exact times, but I want to recall those being somewhat close in proximity within the same hour time frame.
Okay, and then the next text,
I need a lawyer at substation with police.
and then the next text.
Ethan did it.
Okay. What's going through your mind at this point?
Shock,
I need to get away from this loony family.
fear, sadness, all of them, a lot of emotions. We didn't really know what to think.
Okay, and you testified earlier, after I asked a few questions, that you're actually a lawyer.
Yes,
Okay, do you practice any kind of criminal law?
never, no.
Okay. Had she ever asked you for a lawyer before?
I get asked that question a lot by people. She may have, I don't recall.
Okay, so it appears from this text string that you didn't respond via text right away.
No, I recall there was another phone call.
Okay,
Sometime shortly after that last text, Ethan did it. There was another phone call she made to me, because I remember I was still in my HR director's office at the time, and we were together. Maybe another colleague was there.
was it on speaker or?
I put on speaker.
Okay, and what did she say?
I believe she said she was at the police station or had been at the police station and that she needed a lawyer. Could I recommend a lawyer?
And what did you say?
I couldn't think of one at the time. It's not my area. And I just couldn't think of one. I think I told her I'd ask our corporate counsel if she could think of someone to recommend.
Okay. What was going on at the office at this point? Were there people around? The people in the office, did anyone have any outside knowledge of the shooting?
I don't know.
Okay.
I was working with human resource at the time, and we were trying to figure out what was going on.
Okay. What eventually did you decide? Did you guys go back to work? Did you just wait for another communication? Did you start looking for a lawyer?
I did not look for a lawyer. I mentioned as I told her, I mentioned to corporate counsel that this is what we just learned and she's reaching out. If you could reach out back to her, let her know. I know we were closely watching the news, trying to figure out what was happening, what had happened. And I remember I left a little bit early that day to get home with my family.
Why'd you do that?
There were a lot of emotions going on. I just wanted to get home and see my family.
Okay. At some point, did you receive another text from Jennifer Crumbley?
Yes, at 3:39 on this thread, it says I got a text that
So that's about 2.5 hours after she left the office when the shooting occurred?
approximately, yes.
All right, and what does the text say?
I need my job. Please don't judge me for what my son did.
What did you think when you received that text?
I was a little taken back. I was surprised that she was worried about work right then.
Did you respond?
I did. At 5:47 p.m. Let me read the text.
So at this point, were you at work or were you home with your family?
I think I was home at that point.
Okay, and your response was what?
I can't even begin to understand what you're going through. I'm praying for you.
Why you
Ask
text me
Carolyn
with this
to text
hideous,
you some
you know.
attorney recommendations. And Carolyn's our corporate counsel.
All right, and did she respond?
She did. I don't know what time, but it was later after that text. They were taking my cell phone.
Was that the last communication you had with Jennifer Crumbley?
That's the last time I can recall communicating with her. Yes.
Okay, at some point, did the company terminate her employment?
Yes, she was terminated.
Okay, do you
Why?
remember about when that was?
Why? Why was she fired?
I want to say it was a couple of days. I don't remember the exact date. It was some days after this incident, November 30th. Whether it was 2 or 3 days, I don't remember exactly.
Okay. At the beginning of this, I showed you the text string from Jennifer's phone versus your phone. Was there any ever discussion or comments from Jennifer about why she's deleting text messages to you?
Did she ever talk to me about it? No, I never had that conversation with her.
Do you know why?
I don't think that's no idea.
All right, nothing further.
Your Honor, I have quite a bit of cross because there's previous testimony. Is it a good time to break?
No.
Okay.
I don't know.
Good.
All right, if we could just finish with the cross so we can excuse this witness.
Yeah, we had we're 2 hours
Okay.
left today.
I have
would
no-
like to know- You guys aren't starving to death over there, are you?
I have
Okay.
no problem. Okay. All right, Mr. Smith, I just want to go back to a couple of things you said. You and Jennifer, you would not say you guys were friends outside of work, correct?
We were coworkers and friendly at work.
Okay, friendly at work, you guys would make small talk.
Sure, yes.
And you, when you heard that something was going on at the high school, you would agree with me that Mrs. Crumbley sounded very frantic.
When she called us the first time I heard the sirens, she definitely sounded panicked, frantic, yes.
You would agree she sounded shocked and concerned?
Yes,
And you testified that when you saw her at the office earlier, coming back from the school, she had appeared sad.
yes.
it was during that time when Mrs. Crumbley was at your office that you guys discussed the meeting she had had at the school earlier that day.
Yes,
And during that meeting, she told you that the school wanted her to get her son in some counseling, correct?
I don't know if she said this, I think so. I know she said she had to get her son counseling.
She was planning to get her son
Yes,
counseling.
yes.
And it's appeared you were aware she was worried about her son at that time.
Yes,
Mrs. Crumbley is not someone who had a history of constantly disrupting her day at work. Is that fair to say?
it's a tough question to answer, but yeah, it's fair. I don't remember disruptions, no.
I suppose a better question would be, she was not a parent who was constantly having to leave work to go to her child's school for different reasons.
That's what you want to.
I don't recall any other examples of that.
Because she didn't worry about her kid. That's what you're selling. Oh my God.
You never had any concerns personally about how Mrs. Crumbley parented her son.
I never had concerns, no.
And if anything, you would just hear about little bits and details about him. I think you testified about bowling, vacations, camping.
I recall her mentioning, yes.
You recalled the part-time job, skiing.
I don't know, I know she skied. I don't know if he did. I don't remember that.
Okay. And in terms of Jennifer working at the company prior to her being terminated, you would agree with me that she was a pretty consistent hard worker.
I would agree with you, yes.
And Jennifer appeared to take her career very seriously.
I agree, yes.
She was diligent about attending meetings she was invited to or supposed to attend.
Yes,
She was somebody the company could count on to do her job.
I thought so, yes.
And there were times she took advantage of the flexibility that your company offered to allow her to go handle different matters she may have needed to handle.
I know she would have taken advantage of the flexibility to do what I don't know, but sure.
Okay. And I'm correct when I say that Kathy Poliquin, she's the manager of HR, correct?
She was what at the time was the director of human resources.
I'm sorry, Director of Human Resources?
Correct.
Okay. I have her listed as a witness, but I may, based on the prosecution's questions, I may be able to just ask you. But if you're not the right person, can you just let me know?
Yes,
Okay, so you testified that to have
You're
a
only the
single
introductions,
person
lady.
on the company's insurance was approximately $200 per month.
that's what I read, yes, yes.
And you would agree, well, and I'm sorry, when you say $200,
It was bi-weekly, so I don't know.
okay, that's what I was just gonna ask. So it's $200 twice a month.
My understanding is yes.
And
That
if
does
she
not
had
sound
had another person added to the insurance, it would have been approximately $500 twice a month.
I don't have the document in front of me, but I know it went up from +1 and then went up again for family.
Okay, and when it goes up for family, are you aware of what it would have been for there to be 3 people on the insurance?
I'd be guessing, my understanding is family covers as many families you may have, immediate family. I don't know if it's 3 to 10. It covers your entire family, my understanding.
It's fair to say that in the past, you have complained that the healthcare costs taken from your paychecks is significant.
Have I complained? No, because I'm not on the health plan now.
So you're not on the health plan at Princeton, correct?
I'm not on my company's plan, correct?
But I assume you have healthcare through somewhere else.
Correct.
Who cares?
And in this case, with the Crumbleys, you're not aware if they had healthcare through another source, correct?
Correct.
And as far as you know, Mr. Crumbley had a job, a professional job in the past. Are you aware of that?
Yeah, I remember he had a job, a career, and I think he was laid off in between jobs.
And you're not
You know what I'm
aware
writing?
if Mrs. Crumbly,
This is what I'm
Mr.
busy
Crumbly,
writing.
or their
This is
son
all I'm
was
thinking.
covered on Mr. Crumbly's insurance.
I'm not aware.
In addition to the insurance offered at Princeton, There's also a plan through Allied that you guys can take advantage of where you get virtual doctor visits. Are you aware of that?
I'm aware of that, yes.
And those virtual doctor visits are free as part of the Allied benefit.
I believe so, yes.
And you can also get Aflac supplemental insurance for yourself and your family members.
You're getting in the HR world, but my understanding is yes, you can elect those benefits.
Now, the open enrollment period is right in approximately November every year. Is that right?
I honestly don't recall when, but I know it's every year at the same time, and it's open for approximately 30 days, I believe.
And you may not be the right witness, and if you're not, just let me know.
Okay.
Are you aware that
I hate
in
how she does-
November of 2021,
You don't understand, let me
Mrs.
know.
Crumbley was doing anything with
I'm
her
going to answer your
insurance?
question
I'm not
now.
aware, no.
Let me give you a whole introduction to the question I'm about to ask you. If you don't know, how long have you had your current name? So you can ask a question that he can say, I
Now,
don't know.
when you were
What's the 10th digit
texting
of pi?
or exchanging messages
If you don't
with
know,
Mrs.
it's okay.
Crumbley, there was not any point in time where she said to you, hey, Andy, delete these texts, correct?
That's correct.
So she texted you over a photograph of that math paper.
She sent that to me, yes.
Obviously, when you look at that math paper, especially knowing what we know today, it's very alarming.
Yes.
The one thing I do is
And she
put in the banner,
texted you openly
otherwise
that the
you
gun
change my
was
banner
gone and so are the bullets.
to reflect.
That's what she texted me, yes.
And when you were texting with her,
Sometimes I forget to update who's doing the questioning. So
you were exchanging back kind words to her, supporting her and saying things along the lines of, I'm praying for you, I hope everything's okay, things like that, correct?
Well, not things, that exactly.
That exactly. And you knew at the time that you were communicating those things to Mrs. Crumbley, she was in a high state of stress.
I saw her run out of the office in panic.
Not only did you see her run out of the office in panic, you heard her screaming when she heard about the open shooter.
I heard her like yelling, screaming that she had to leave. I forget exactly, but there was a shooting event going on at her child's school.
Definitely a strong reaction from Mrs. Crumbley about what was happening.
Yes.
Now, after Mrs. Crumbley found out more information, we saw the text where Mrs. Crumbley is saying, I need my job. Please don't judge me for what my son did, correct?
That's a text, correct?
Now, at that time, you're aware that James Crumbley was laid off.
I knew he was in between jobs. I don't know what he was doing at that point.
she might
And
be
so
state appointed.
Mrs.
They might not have
Crumbley
any
is
money.
certainly voicing the concern to you, I don't want to lose my job, correct?
She sent a text, I need my job.
As far as you knew from working with Mrs. Crumbley over time, she liked her job, was good at it, and valued that job.
I thought she was good at her job, yes.
And her text indicating she wanted to keep her job, you have no reason to believe she didn't want to keep her job.
No, no.
I have nothing further.
Redirect.
Nothing there.
It made it sound like she was going to go for like an hour and a half.
Step
There.
down there, excuse.
Thank you so much.
All right, we want you to.
I would have asked why she was fired. Why the hell did you fire her?
How about?
I don't know why you didn't ask that.
Overriding one?
It's not essential. It's not a vital question.
Today. If one of the jurors was making a snowman, another one was. All right, good. We'll see that, okay?
All right, jury.
All right, you may be seated. You know, could I have the prosecutor approach on an unrelated matter, actually sort of related matter, which is the other, are you off? Are you off?
Loving
Yes. I just want to ask you a few questions.
All right. So I think that we're done here. I think we're done. So This is basically this is what I've been left thinking all day. That's what I'm left thinking all day. Back! Sorry about that. That was there after. All day. This is all I'm thinking. Why? Why? I'm going to tell you right now. If Jennifer Crumbley is convicted, it is, in my opinion, a large part of the blame. We don't know what's going through the minds of the jury. We don't know. Maybe they walk in there. If she's convicted, it could be that she's convicted because sometimes you get a bad lot of people from a jury pool and you have no chance. You're like a dead man walking. You're like Donald Trump in front of Lewis Kaplan. You just got or Judge Engoron. You just got no chance. That's possible. So we will never know. And we will never, ever know, God forbid, if she is convicted, what led to her conviction. It is all speculation. I will say, in my opinion, her failings with respect to her cross-examination of Shawn Hopkins and this guy, and Herr Ejak, whatever his first name was, that she had an opportunity, and she sort of got there eventually with Ejak. Eventually, but she needed to be pounding and pounding and pounding the lack of foreseeability. We can never lose sight of the fact that this entire case is that you created this foreseeable carnage, your reckless disregard, foreseeably created this. So eventually she got to the whole thing where she sort of said, you didn't know, or failings that you didn't ask about the gun. It took her so long to get there that the jury is zoned out by then. It should have been come out firing. You were the professionals. You were the ones who should have known. And you know what? Harry Ejak did a pretty good job of explaining, I can't go through his bag. Well, you know what? Maybe if you would have asked him about the gun, you would have seen suspicion in his eyes. He would have seen suspicious reaction. You had here a kid who's looking up bullets the day before, looking up school shootings that morning, drawing disfiguring, disturbing images. And you know that a lot of kids are all wrapped up in guns. So you didn't put this together and didn't see him as a potential threat. You never asked for him to go home. You never even told him that he had to go home that day. You never said, you thought if anything, he was a threat to himself and then he gets counseling sometime over the next 48 hours. You, the professionals, could not predict that he was about to engage in a school shooting. He didn't even look remotely suspicious. He doesn't look remotely suspicious. That's what you just said. He didn't look remotely suspicious. But now the state wants to claim that my client should have foreseen this, should have foreseen that, oh my God. If you're saying you didn't know this because you didn't have knowledge of the gun that we had, how do you not have knowledge of that when you know that half of your school is packing? Maybe not at school, but you know that they have access to guns. Why would you not ask the question? You didn't ask the question to the kid. You didn't ask the question to the parents. You didn't ask the question to anyone. You're the professionals. You're the ones who have all the training here. You didn't ask any of these questions. Why? Because it didn't seem remotely fathomable that was what would happen. And yet the state wants to say, oh, this is all foreseeable, all foreseeable. That's what you needed to pound with Hopkins yesterday. That's what you needed to pound with Ejak today. And this lawyer, I'm sorry, this is the problem. This is the problem. This is the problem. You need to hit this. Half the time when she's talking, this is what I'm thinking. It's terrible. It's terrible. And the sad thing is that if they succeed here, it sets a precedent. Other parents are now going to have their necks in a vice. Anyway, that's the story. I don't know if I don't expect to be streaming this afternoon. I'm going to send you over to MLS Making Law Simple. I'm not sure if Kurt is streaming this trial also on civil law, but I'm about to wrap up here and send you over there. Tonight, I'm not going to do my regular show. I'm going to be doing a 24-hour show starting at midnight. At midnight, 24-hour. Basically, I'm marrying off a daughter, celebrating her wedding. During the course of that stream, I will have guests and more guests and more guests and more guests. I'm going to be covering Fannie Willis and Nathan Wade testifying tomorrow. That's going to be incorporated in the whole celebration because let me tell you something. There's no better way for me to celebrate my daughter's wedding than watching special prosecutor against Donald Trump, Nathan Wade, squirm on the stand. I am very, very, very much looking forward to this. It's going to be fun. So I urge you, check it out, pop in. If you feel like popping a little champagne with me, buying me a drink, I am looking to raise money for my kid. I have to pay for my daughter's wedding. The father of the bride. Hey, I'm very happy about it. Very happy about it. But I do got a couple of bills. I will see you all at midnight. Until then, I say to you, my friends, I thank you for joining me. Take care of yourselves. Be happy. Eat the bugs. And as always, my friends, make sure I look good. Yes, as always, I say to you, Godspeed.